In the city, I know that it's killer be killed, eat it be ate, snake to be snake. I walk out alone, but I'm clutching my drink, cause I know they ain't right and I know that they fake. And I'm trying to tour, but I know that these niggas be snitching and pointing me out to the jakes. When I gun at a nigga on aim for his waist, I'ma make sure he hit and stand over his face. Now they take that they mad cause they don't got no case in his first 48 and they ain't got no lead. While me and Lil Bro, we back smoking on trees. When you break down the wood with that bitch down with lean. When I'm smoking your partner, I turn to a fiend. I ain't throwing the doobie, I'm facing the weed. When I'm smoking your partner, I turn to a fiend. I ain't throwing the doobie, I'm facing the blunt. No cap, let hummus some rats. When it's time to go kill, while black on the hunt. We do shit out movies, but this ain't a stunt. Wrong move, turn this bitch to a scene. I high off the shrooms and I mix it with beans. Wide awake, seeing shit from my dreams. Moving slow cause I'm full of the lean. Catch the boy lacking, turn here to some green. I'ma tell you the truth, I'm high as a bitch. I'ma lie to the judge cause I'm never asleep. I'm rapping and trapping till I'm old and rich. I'ma buy me some land and duck off with my bitch. Tryna sort out my price and get found in the ditch. With a face full of maggots and half full of mud. I don't care what you reppin', don't call me your blood. Put in work for the set, they gon' die by the cuz. Tryna get up your name, you gon' die by some bugs. I was just in the trenches, I know where I was. All it take is one Drake, man, them bitches went wild. I was down on my dick, I just still in our car. I pop a few bosses to send me to Mars. When I woke up in jail, I had to take a little pause. You a change on your gang, I'll die for the cause. No cap, I'ma die for the cause.
Let's get back a motherfucker.
I love me a cougar. I'm talking about that thing with some age on it. Teaspoon of vinegar will get it right. Make me wanna put my name on it. She put a crease in my jeans. She all that I need. Ham hocking her green. I love my cougar, Miss Irene. Cook me a nice meal every Sunday. Hell, I'm go mow the lawn for her. Clean that garage cause her husband passed. Moment of silence for Mr. Charles. Now I'm finna go work on her. She thick as cornbread, got some good old yams. I get a high blood pressure medicine for her. She just can't stay away from him. I love my cougar. I'm talking about that thing with some age on it. Teaspoon of vinegar will get it right. Make me wanna put my name on it. She put a crease in my jeans. She all that I need. Ham hocking her green. I love my cougar, Miss Irene.
All right. Hey, hey, hey. How y'all doing? How y'all doing? How y'all doing? How the fuck are y'all doing? Okay. So we are back. We are at it. Okay. We finna get this shit done. Okay. We finna get this shit done. As y'all can see, we got the documents. This document in particular that we're gonna review today, because we're not gonna do all of them in one day. I can't do that. Not this week. This is a 193 page document filed in the 296th Judicial District Court in Collin County on July 7th. What's up, Leisha B? And this is what we're going to go over today. I got a poll in the chat and it's asking a question. Could Carmelo's parents have done anything to stop these people from railroading? I'd love to know what y'all think. As promised, I'm going to start the day off. I'm going to start this live off by me keeping my freaking word from yesterday, okay? Because I try my hardest to be a woman of my word. And boom, shakalaka, there's those 5 memberships. Okay, so we got Ashley Marie with her ugly. I'm just playing a girl, not ugly. But we got Ashley Marie. We got Red Vines and Popcorn. Harlem Quinn. Lovely 8822. And Sarah did it again. Okay. Welcome to the Sonya Quarter Thoroughbred motherfucking family. So, like I said in the title, this live is a public live and it's a members only chat. Why? Because I value my members, baby. And some shit just be about them. You know what I'm saying? Some shit is it's just all about my members. Okay? Now I do have the 99-cent membership if you would like to participate in the chat. If you don't mind just watching and not being able to talk, then hey, it is what it is. We are on Facebook as well. Okay? It's CVAL Madam O. We are on Twitch as well in Sonya Quarter CVAL. Okay. I will start a goal because hey, why not? Right? Why not? Fuck it. So we're gonna do 1 hour. We're gonna do 10 super chats. And we're gonna do them babies at $5 or higher. Okay? At the till. What will happen? We'll open it up. Open chat. I don't have a problem with not reaching it. It's just something for engagement. Okay? YouTube creators email said do things for engagement. I've done a poll, I've done a goal. Okay. Adam, it's above me now. To the Sonya Quarter family that can chat. Hey, how we got Alicia B in this bitch? She say she think they fast talked the parents. So she don't think they could have actively done anything. Okay. And just for replay value, let's go over those profiles. Okay. Who are now Sonya Quarter Thoroughbred family. Okay. That's me keeping my word. This is the first recipient. Okay. This is the second recipient. Okay. My girl Harlem Quinn. I ain't seen her in a minute. Met her over at the Room Shakers. We was modding over there together. We got Lovely. We got Sarah did it again. I have no clue who Sarah did it again is. I don't know. Is that the little white girl? The little young ass white girl that was coming around? I don't know. But my quarter girl Alicia B say I think they fast talked the parents. I don't think that they included the parents. But I guess we finna see now, right? So just like we are waiting on the Mo3 trial to see what actually happened, right? Well, with this Carmelo Anthony trial, this is our way to see what actually happened. On yesterday, we reviewed the 4 documents uploaded in the case of Melvin Nova's assassination, where a lot of the things that we felt like just made common sense, but we hadn't actually seen the state say them yet. We saw the state actually saying those things in those documents yesterday. So today I think will be a day just like that, but in a Carmelo Anthony case. So we dealing with Dallas County on yesterday. Today we're dealing with Collin County. They got a lot going on out there. We got a lot going on out here in Ellick too. They just found the body of a Sonya Quartering, of her son. They actually found it around the corner from my house. I didn't even know. I just found that out today. Prayers and condolences to that family. Yeah, so it's a lot going on here too. I'm gonna tell y'all the difference. The shit that go on in my little small community, 8 times out of 10, is somebody I know, somebody that I've held in my heart, somebody that I've had life experiences with, and as someone trying to come out of this first era of grief, I do better dealing with people that I don't know. Not because I lack empathy or care. It's just that it hit different. Okay. Now, if anybody out there would like some insight on what's going on here, because Lord knows it's a lot and you don't mind covering it, baby, I'll get it all to you. Okay. I ain't gonna holler this Alexandra business. Baby, you can have this shit. Okay. You can fucking have this shit. Quick, fast, and in a motherfucking hurry. Absolutely. All right, so y'all ready to get started? Let's get started. It's about to storm here. I got those two girls in there, y'all. I think I set them up real nice. I hope so. It was outside, but it's about to storm, so they in. Hopefully, they allow me to get through this presentation. Okay. So it says defendant's motion for new trial and brief in support to the honorable. I guess they just got to put that because I don't see Roach. Matter of fact, hold on. Matter of fact, just bear with me for a second here. Cause I think we got to have Roach up here. You know what I'm saying? I think we got to have Roach up here. I think the Roach got to be seen. I don't think the Roach honorable. Girl, that's what I'm saying. I don't think the Roach should have to run from these. Let me see who else should be up here. Who else should be up here? Who else should be up here? Let me see. Oh yeah, let's get Worski motherfucking ass up here. Let's get them up here. Let's get them up here. Yeah, we're definitely gonna add these sorry son of a bitches. Yeah, we're gonna add them. Yeah, we definitely gonna add them. Fuck that. Get y'all ass up here. Y'all did this to that goddamn boy Toby Shook and Worski and Roach and Mike Howard. You weak motherfucker. Yeah, let's just make sure we add them. I got to put them up here because they got to take some kind of motherfucking accountability. Hey, Kivia. Kivia sent them floating hearts, baby. We appreciate nature. See, when I see people like Kivia come in, I be feeling bad about the members only chat and shit, child. I ain't gonna lie. But I did get that email that said, hey, you hadn't done nothing for your goddamn members. I say, all right, okay, all right. All right, okay, all right. Somebody missing. Somebody is missing. Oh, there he is. Yeah, 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 yeah. So bear with me. Let me just get these motherfuckers up here because they don't get to hide. Right? We're not gonna let them hide. I actually had them in another scene, but that ain't the scene that we're using for this. So, Mm-hmm. Let's make sure we get their whole asses up here. Because they did it. They the ones did it. And don't worry. If you are somebody who be like, okay, so what not though? Y'all talking about it, we talking about it, but what we gonna do after we talk about it? Don't worry. I got that too. I got that too. No way we just gonna do nothing. Okay? No way we just gonna do nothing. Oh shit. At work listening. Come on through then, boo. Money, 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 money. Money. Money, 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 money. This whole ass nickel. Who is this? Which one of y'all is this? Okay, there's this whole ass nickel. Let's just get you up here. So, because Bill Worski, I'm going to put Worski right here by Toby because he the bitch ass nigga that actually made the deal with Toby. Right? He's the bitch ass nigga that actually made the deal with Toby Shook. Bill Worski of the prosecutor's office. And that's what I'm asking Yella. Like, excuse me, Marquise? Marquise DeAndre, did you not see what happened to that boy? Hmm? Did you not see what Toby Shook just did to Mello? Huh? But it's all good. Yep, it's all good. It's all good. All right, y'all. And because of more money, we have one of those motherfucking goals met. If y'all care to talk, get the 99-cent membership. Alicia, if you could drop it in the chat form every so often, the membership link. But we're gonna go ahead and get started. If y'all don't care whether you could talk or not, you don't have to worry about the 99-cent membership. We did go ahead and gift the memberships that we were supposed to give from the live yesterday. Okay. And now we just gonna keep going. Make sure y'all hit the like button. If I see that the likes are lining up with the eyes, y'all know I'll go ahead and just say fuck that goal and we'll turn this bitch up. All right. But because they say I need more engagement, then here we go. All right. Now, since we have all of these hoe cake ass motherfuckers up here who are responsible for railroading this child, I can now proceed. Yes, indeed. Comes now. The defendant, Karmelo Sincere Anthony. I love his name. By and through the undersigned counsel and pursuant to rules 21.1 through 21.9 of the tech. Wait a minute. I just heard another kink. I just heard another kink. Where that kink at? I heard. There you go. Hey, Sonia Quarters. That's what they say. They say, hey, Sonia Quarters. Let go, Neek. Hey, Neek. What a link for the membership? Hold on. Let me grab it. Let me grab it. Let me grab it. Thank you, boo. Thank you, boo. Neek say she might want you other motherfuckers to be able to talk in the chat. I think Neek and Money Mo, I think they want y'all to be able to talk. It's something about these quarter girls and these quarter boys that just have a heart that a lot of people just don't have. Something about people who choose to fuck with the quarters, they really do be having morals and a heart and shit like that. You know, shit that you don't really get when you go to many other places on this here application. Let me drop this link. Boom. Boom shakalaka. Boom shakalaka. There it is. Keviana say, bitch, I'm on Twitch, okay? Keviana, Kevia say, bitch, I'm on Twitch, okay? She say, bitch, I follow. I support the Sonya Quarters of the internet, bitch. I'm on Twitch, bitch. I will talk and you will see me. Let's go, Kevia. Let's go, Kevia. Let's motherfucking go, okay? All right, y'all. So again, y'all, this document in particular is 193 pages, okay? We got to get through it. We got to get through it. We got to get through it. Okay, so this is pursuant to rules 21.9. Okay, Rob say he up in this bitch. Rob, Rob say he up in this bitch, y'all. Okay, hey Rob. So pursuant to rules 21.1 through 21.9 of the Texas Rules of Appellate Procedure, moves the court to set aside the judgment of the conviction and sentence and grant a new trial. What happened to that boy? Nika say, madam, let them the fuck in. Supporting from the clouds. I wish I could hang with my bitch today because, baby, this some straight bullshit, but I'll be back soon. Thank you, Nika, baby, and don't worry about it. Check this out because this is one of three. Okay, we have all three post-trial documents filed on behalf of Karmelo Anthony. I literally I have them in my possession. They ours, baby. They are officially a part of the Sonya Quarter archives. You heard me? Okay. None of these lives are going on members only. All of them will stay open to the public. Share them, clip it. I don't care. Okay. Nika, enjoy yourself. We'll be here. I got you on the TV so I can see the YouTube chat too, girl. Okay. Mm-mm. Hello? I'm y'all take a nap. Y'all want me to referee y'all playing? I'm not gonna do that. I'm not gonna no. If she broke it, then y'all both have that one till y'all break that one. No. Tape it back together. Husband, text it to me. I just clocked in. I'm at work. Okay. Text me and tell me what you was trying to tell me. All right. Let's motherfucking go. And did you see them bitches selling the transcripts for 10 bands? Sorry, piece of shit. Who? Who selling transcripts for 10 bands, Nika? Who the fuck? What? Dude, what say, huh? Nika, what the fuck you talking about? Nika, what are you talking about? What the fuck? What in the hecky Becky? They and then it ain't even the transcripts, Nika, because the transcripts have not been the this shit ain't even been transcribed yet. So somebody trying to beat. That's all it is. That's somebody trying to beat. They haven't even transcribed it yet, as we are going to learn in this document right here. They done already put a price on it. God, I ain't even got that shit. Where you see that at? Drop the link for that. Let's take a look at that real quick. Yeah, drop. Nigga, don't piss me off. What? Every day I try to come on this motherfucker and be professional. Every motherfucking day I try to come on this bitch. And, fuck that. Drop that link to that. Every day I try to come on this motherfucker and be professional and not be cussing and shit. And every day these dog ass hoes do something else fucked up. Hello? Seven. Hold on. Let me mute this. Okay, and nephew, just text me because I just started. I just hit the live button. I just clocked in. I love you, Nika. You lying unless you drop the link. If you don't drop the link for it, it never fucking happened. It never happened. If you could type in the chat, type them motherfucking caps for Nika, because Nika is capping. She is capping. Nika, we don't believe you. You need more people. Oh, look how I got him setting up there. My bad. All right. Yep. Until y'all drop the caps for Nika, okay? And until Nika gives us that, it did not happen. She capping. She trolling. She's trolling. Mm-hmm. Mm-hmm. Yep, Nika's trolling. Nika, you done made my nerves real goddamn bad. Fuck the Newport. I done grabbed one of my husband goddamn Black and Miles. Okay? I done started rocking. Let me take this robe off. I done got hot and everything. Jesus. Okay. All right. So they said to the dishonorable bitch named Judge Roach, the lawyers is coming now on behalf of Carmelo Sincere Anthony, pursuant to the rules in the Texas Rules of the Appellate Procedure. They say the court needs to set aside the judgment of the fucking guilty conviction in 35 years. Um, and they need to fucking give him a new trial so that they can actually try to give him a fair trial. Y'all say he guilty? Well, then stop trying to play these rockhead ass games and show that he's guilty. The defendant moves for a new trial on 4 grounds. The first one, the court committed structural error when it materially restricted public access in violation of the right to a public trial. Second, the state's repudiation of the parties' unrecorded evidentiary agreement, aka the gentleman's agreement. After the defense relied on it, coerced the waiver of Mr. Anthony's right to testify. All them bitches kept saying, he should have testified. Why didn't he testify? Why didn't he testify? Well, because Toby Shook and Bill Worski coerced him to give up his rights to testify and denied him a complete defense, Toby Shook, in violation of his constitutional rights. Last but not least, the trial court improperly instructed the jury on the applicable law. So, Roach improperly instructed the jury. His jury instructions, which I'm waiting on it. Okay, I'm trying to get that too, but I think it's in here somewhere. Last, oh, that was third, and then fourth, the cumulative effect of these errors warrants a new trial in the interest of justice. The introduction. This case presents a structural public trial violation. The court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administered restrictions that foreseeably excluded members of the public from a high profile criminal trial, required to make record supported findings and to consider reasonable alternatives to closure. So what I think is that they was doing shit that they thought was going to cause the niggas to act a nigga. And then that would be their just cause for shutting off this trial. However, brown American people came in there as brown American people. And the only motherfuckers acting a nigger wasn't even brown skin. How about that? So they fucked up. The court did neither. The access regime limited public attendance to a narrow daily admission period, a small number of seats, and no continuing overflow or audio or video access after jury selection. Because that closure affected the trial proceedings themselves, and for the three additional grounds set out in this motion, Karmelo Sincere Anthony said, bitch, throw that shit out and give me a new motherfucking trial. In support, defendant shows the following. Defendant's motion for new trial and brief in support. This is the factual background. A, the case and the verdict. This case arises from when YALL Churn was bullying Karmelo at the track meet. Karmelo Sincere Anthony was charged by indictment with the murder of the bully Austin Metcalf, alleged to have been committed on or about April 2nd, 2025. We don't know if he actually did it because they won't show us the real footage, the clear footage. They will not let us know who I was under that motherfucking tent. Karmelo pleaded not guilty. His defense at trial was self-defense. That he used force he reasonably believed immediately necessary to protect himself from that gang of thugs under the tent. The court's charge submitted the offense of murder. Crazy fucking work. The lesser included offense of manslaughter and the law of self-defense, including the justified use of deadly force. The defendant did not testify, and on June 9th, 2026, the jury found the defendant guilty of murder, and the court imposed a sentence of 35 motherfucking years confinement. These matters appear from the indictment, the court's written charge, and the judgment. They wanted to book break Karmelo because their children were inferior to his accomplishments. 3. This case drew national attention from the outset. And when it drew national attention, Roach said, shut that shit down. We don't want everybody out there paying attention to what's going on in Collin County. Because we already know that we finna fuck him. That's why we charged him when he should not have been charged. So when everybody was looking at this a year ago and then stopped, it was by design, okay? Where was I? And the court appointed a public information officer to assist with media credentialing, communications, and access logistics. Now, if y'all remember the first time we went deep off up into this, we found out that there used to be a Collin County court officer that got in trouble for leaking information. The more I listen to other people's content, it seems like that was a brown-skinned man. Okay? And this is why Judge Roach, instead of him going with the public information officer already there, he brought in this very conservative dude off the street. You know what I'm saying? Somebody connected to Fox News. You know, Fox News with the Will Kane show. You know, the Will Kane show that the Metcalfs went on the day after this event. You know, the one where they tried to lie and say that Jeff was there in the home. Remember the one where Hunter went to telling every fucking thing? Y'all remember on Fox the Will Kane interview on April 3rd, the day after this happened, when Will Kane told them? Yeah, we know some people that know Austin. The circles got tighter. This hit close to home. Yeah, that Fox. In practice, public and media access were administered through that process. What follows is how that access was in fact administered: before trial, at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. How many fucking, come on now. Y'all think they wasn't going to go with mainstream media only when the person that they hired to be a court public information officer was a mainstream media fucking vet from Collin County? B, the secrecy before trial, the gag order, chamber conferences, and no public pre-trial hearings, such as the one that someone from the Sonia Quarters will be attending in Dallas County on the 16th of this month. Mhm. Seventh floor, look to the left, first court to the left. That's what they told us on the phone yesterday. All right. The closing of this prosecution to public view began more than 10 months before trial. On July 28, 2025, and we saw that, right? We definitely went over that document. Acting soi sponte. Oh, that's a nice word. On no party's motion, the court entered an order prohibiting extrajudicial statements. All right, so what was that, day before yesterday? The last time we covered Karmelo, right? I took y'all to the Collin County Courthouse website, and then I showed y'all that all of the Collin County Judicial District judges, I'm talking, all of the judges had adopted these new rules. And one of the new rules said that the judges could now do this right here, okay? Do motions, hearings, and everything without either of the parties filing any motions, okay? Go to bed. Go to bed. Go to bed. Go to bed. Close my door. Well, you ain't got to close it because y'all ain't finna be loud. Don't close it. Because if I hear y'all, I'm coming in there and I'm going to throw something at y'all. Go to bed. Take a nap. It's 5 o'clock. Take a nap. We've been up for 5 hours at this point. Take a nap. We supposed to travel tonight, so take a nap. My bad, y'all. On July 28, 2025, acting soi sponte and on no party's motion, the court entered an order prohibiting extrajudicial statements, a gag order binding the parties, their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court appointed officials, which by its term remained in force throughout the trial. Covered persons with firsthand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. So, anybody with firsthand knowledge was restricted from saying anything until after the conviction. Well, Roach, why would you do that? Why, Roach? Why would you do that? Hmm? Anyway, the gag order's terms were sweeping. Unless first approved in writing by the court, no covered person could make any extrajudicial statement that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness that discusses evidence anticipated to be introduced at trial, or that intends or is likely to influence public opinion or potential jurors. Restrictions expressly applicable to any public medium including traditional news outlets and social media, and enforceable by contempt, which could be jail, fines, attorney discipline, or other remedies. So I want y'all to know that this was done so that they could continue to paint a picture of Karmelo as a heartless, single mother, raised, troubled school kid that was a thug. They wanted to also continue to be able to paint the picture of the Metcalf twins, right? Austin, a martyr who was just doing what was right, preventing Karmelo from stealing any of their belongings from under the tent, right? They wanted to continue to be able to spread that narrative. They wanted to protect the boys. So nothing about them could come out. All of this was done to protect these other children. Its findings were three sentences: that media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial. I call cap. It is illegal, Lee, and we're going to cover that too. It is illegal. I ain't gonna say it's illegal, but it's definitely unconstitutional. It's definitely a violation of his civil rights, and they violated ethics codes. Okay, but we're gonna get into that too. And they keep saying that it's all for his right to a fair trial, but the actions is actually completely contradictory. All of their actions is actually what robbed him of a a fair trial. Okay, that alternative measures, venue change, juror screening, sequestration, would be inadequate alone, and that narrowly applied speech restrictions are necessary to protect juror impartiality. Yeah, what happened at Juror Appreciation Week? Hmm? Who all y'all invited up there on May 4th specifically? Who was the 500 plus that y'all invited up there, summons there for Juror Appreciation Week? I want to know how much of y'all jury was pre-selected from Juror Appreciation Week. That's what I want to know. I bet your bottom dollar that they had them jurors, because by now the jurors would have spoke out, right? The jurors would have spoken out by now. The judge did. Everybody else spoke out. Why haven't we heard from the jurors? We heard from the jurors after the Diddy trial. We hear from jurors after high profile cases. I'm willing to bet that they went an extra mile and had those jurors to sign something saying that they couldn't speak about this. Oh wow, so your brother who's a Collin County resident didn't know anything about it until you told him. Ain't that something? I saw quite a few people in chats that was saying I live out here and I didn't even know it was going on. Hmm. No evidence is recited, and that's required. The order permitted only procedural announcements, an example, hearings, schedules, court filings, and statements required by legal or ethical duty, a safe harbor that presupposed filings the public could see. By its terms, it would yield only to further written order of this court, and the amended order later reaffirmed it until the completion of trial, is what it said. In the 10 months it operated, no person was ever alleged to have violated it, so far as the public record reflects. Which we know that's a lie. The Metcalfs was talking through people. And your brother had jury duty the day they selected the jury? Oh, wow. Baby, he wasn't a correct complexion. Okay, they put the minorities. This is a reason why why black Americans don't have no protective laws, because we allowed these people to group us in with everybody a minority. That's a woman of any ethnicity. You know what I'm saying? Minority. That's our group. Minority. Anyway, the substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conferences with the court, including a May 21st, 2026 conference in chambers at which the parties' evidentiary understanding was described to the court, and a May 29th, 2026 meeting addressing trial security and scheduling, occurred in Roach's chambers outside of open court. No reporters record Wait a minute. No reporter's record of them exists, a matter the hearing will confirm. So they didn't even have the court reporter in chambers. I know that in chambers they absolutely do still have a court reporter. Whatever. No pretrial hearing was ever held on the access restrictions, and the register of actions reflects no such setting. The public docket discloses no motions in limine. I thought so because I was looking, and none of the substantive pretrial litigation that in fact occurred. Filings that were hand delivered rather than filed in the district clerk's public record. A member of the public who examined the docket before trial would have found no hearings to attend and nothing to read. He's so fucking guilty. Just get over it. He did it. He killed him. Just get over it. And to think that they got adults who claim to be patriots. Let me just say this real quick for the alleged patriots. Y'all ain't no motherfucking patriot. How can you be a patriot to the United States and to this Constitution when y'all don't have no motherfucking problem violating this young man's constitutional motherfucking rights? Kivia, I apologize. I was reading, so I didn't see. The total fee requested to compile a full multi-day trial record is approximately $10,000. It's on Google. Oh, wow. Oh, wow. Okay, so Kivia say Quarter Girl Nika is not stunting, and that they did. They actually, the appeal record package is on Google. Okay, so let me ask this. So are you saying that that comes from the Anthony family and the appellate legal team? That they're saying that that's how much it charged them to compile the appeal record package, and that if anyone wants it, they could donate $10,000 to his appeal or some shit? Did you hear the audio of him saying it was self defense? Yes, I did. I did hear them slow it down. Somebody who was what I was asking for. Can I get somebody who's good at this to actually um fuck with this audio and this video? And so somebody did, and I did hear that. Will Kane kid in the same district probably was at the meet. Yeah, I pulled his record too. I know both of Will Kane's kids, and they played soccer, and I can't remember what else. I don't want to lie. Official trial transcripts for the state of Texas versus Sincere Anthony are reportedly placed at $10,000 for the total per Google. Okay, so that's not official. That's probably, I know people who used to sell sand that they just got from anywhere, and then they would claim that especially in San Antonio, They would claim that it was Alamo sand, and they literally would just fill the vial up with dirt and sell it online, and people bought it. You got people who go and go online and try to buy holy water. You know what I'm saying? People, some people, some people. And because they think that everybody is like those people, they think all of us dumb. They think all of us done is dumb. That's why they do this shit so boldly. Yeah, them prayer cloths and shit. Yeah, absolutely, absolutely. All right, let's keep reading. We're on C. The amended order, the written terms of access. On May 18, 2026, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum, entered to govern all aspects of the trial proceedings. The order recited the directives of Waller versus Georgia and Shepard v. Maxwell, found that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, and promised reasonable public access consistent with constitutional requirements. Okay? This is what they guaranteed. Doesn't look like they got it. Okay? It don't look like that's what they gave. Period. I think they lied again. I want to go look at the Constitution, y'all. I need to go read exactly what it says. You know what I'm saying? In short, a few places. I think what's funny is that if I heard correctly, the judge cited these two cases, Waller v. Georgia and Shepard v. Maxwell, as his just cause precedent for the way he closed the public out of this trial. But this dream team of attorneys, if I'm not mistaken, we're about to see throughout this document, are going to pick him apart with these same two cases. All right, so the next section is defendant's motion for new trial and briefing support. This is number 8, same section, my bad. Its operative terms were these. The courtroom will be open at 8:30 a.m. for the media, 8:40 a.m. for designated family members, and 8:50 a.m. for the general public. I read that fast because we already went through that. No more than 9 members of the media will be admitted. Seating will be on a space available basis. The doors would close promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess, and no person who left could re-enter except at recess. I heard one content creator said that she had been holding her pee and causing herself to be dehydrated because she ain't want to miss nothing. Okay, I see a few people that just came in on YouTube. We do have a goal in place for the next 13 minutes. We 7 away to open up the chat. And like I said, if I do see the likes matching the eyes, I just may open it up for y'all anyway. And I did give out the 5 memberships that I told y'all I would do on yesterday. Okay. The goal was met after we got off live, but I still kept my word because it was in the same day. Okay. So I did honor uh, me saying yesterday, if y'all met the goals, the 2 goals with the like button and the super chat goal, that I would give out those 5 memberships. And I did. Okay. So I just wanted to say that to whomever was in here. Also, there is a 99-cent membership that you can purchase for the point of chatting in members only chats. Okay. All right. Let's keep going. All persons attended were required to dress in appropriate business attire. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, or images related to the case or otherwise distracting or potentially prejudicial were banned. That's normal. The order appointed Steve Stoller, identified in the order only by a personal email address and a cell phone number. When I was going through that, I was looking and I said, Gmail? Like, I should take a screenshot. I should take a picture of my notes because I literally circled and read because I was going through all the people. I was composing the people. And when I got to him, Gmail at gmail.com for somebody from the courts, it was strange to me, but now I know why. He ain't from the courts. Um, as the court appointed public information officer, committed media credentialing to that office, and announced that the court will not intervene in or resolve disputes among members of the media regarding access or seating. So basically, he said, if you got a problem with how I'm running this shit, eat it and shit it out because the judge gave me the authority and they is not going to override what the fuck I say. I don't know if I'm the only one, okay, that take that like that, but that's what I see. You know what I'm saying? That what I see, keep you. Okay. Um, where we at? The order contained no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object to any of it. Because how hard would it have been if you want to protect the children testifying, protect the identities of the jury? Ain't that how they do all the rest of the public trials? Why couldn't you just let the public hear what the fuck was going on? And the commissioner's court, who provided IT and audio and visuals and shit for this trial, why couldn't they just make sure that their person that was running this shit muted it when they spoke a child's name or some shit? You know what I'm saying? Like, there were so many other ways, if their intentions were as pure as they claimed they were, there were so many other ways for them to get that done while protecting these people. But because their intentions the whole time was to fuck Karmelo without as many witnesses, with as less witnesses as possible, that's where they fucked up. Number 9, the order also closed the courthouse grounds themselves. It placed the entire courthouse campus, including parking lots, sidewalks, green space, or any other designated area, under a nightly curfew from 11 p.m. to 6 a.m. beginning May 31st, 2026. It designated restricted zones on an attached exterior map, and it ordered the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during the trial, which we know from watching people record what was going on, that they absolutely did not enforce this. Why? Because the demographic that they thought would be the violators were not the actual violators. Okay. Under the order's enforcement clause, any violation, including a citizen's presence in a courthouse parking lot or on the green space beside the courthouse before 6 a.m., exposed the violator to immediate removal from the courtroom, courthouse, or courthouse grounds, and the imposition of sanctions, including jail time, which is contempt of court, and no warning is required prior to enforcement. No findings of any kind of violation. Okay, VPN, you just gonna pop up on top of my screen. Okay. Um, Accompanied the curfew. Yeah, there are findings. They're not on record, but Baby, there were plenty of people there that saw violations. Okay. D, access and operation. The curfew, the parking lot, and the pre dawn line. In operation, admission had almost nothing to do with the orders stated 8:50 a.m. public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours, often between 4 and 5 a.m. before court was in session and while the campus curfew was still in force. The sheriff's deputies enforcing the order stopped arrivals at the parking lot and restricted entry on campus until the curfew lifted at 6 a.m. The queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceedings convened. A member of the public who appeared at the order's appointed hour of 8:50 a.m. had, as a practical matter, no prospect of a seat. If you came when they said to come, you wasn't getting in. Ain't that a bitch? I think I should have that song just playing softly in the background while I do this. Ain't that a bitch? 11. The line itself was administered without published standards and not even handedly. They so ordered, but they ain't got no motherfucking order. Individuals were permitted to move ahead of members of the public who had already waited 4 hours. Thelma Anderson, who arrived early on June 6th and initially held approximately the 7th position, was displaced to approximately 35th beyond the number of available seats and was excluded from that morning's proceedings. Tamitra Carter, identified as number 7 on an early arrival list, was removed from the line on June 5th and lost the morning session. Admission was run through two lines, one for a media list, one for everyone else. And media outlets denied credentials were directed by the public information officer to seek entry through the public line. Were as a Collin County Sheriff's deputy administering the line acknowledged on video, persons who print out whatever and make themselves like they are media consume the public's few seats, a practice the officers conceded they could not police. How can they ain't tell that to the judge when he ordered them to enforce these orders? They ain't tell it to the judge. They ain't say, Judge, we don't even know how to do these. Thelma is a former prosecutor in Dallas. Oh, Lord. Yeah, they ass was in trouble then. See, they don't even be knowing. They don't even be knowing who the fuck they be turning away. E, inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. The courtroom held approximately 70 seats. By the court-appointed public information officer's own written account, 15 were allotted to the prosecution's family, 15 to the defense's family, and 9 to the media, including a courtroom sketch artist, with additional seats for the court staff, leaving only about 24 or so seats for the general public. The trial judge later confirmed the arithmetic on television. That's what they say. Later confirmed the arithmetic on television. Okay. Some 200 requests by the media and 27 to 32 public seats that we rotated every day, according to the Roach on his post-trial media fucking tour. None of these allocations appear in any order. And the 15-seat family allotment was not honored in practice. The defendant's own family, my lamb from glory, the defendant's own family was limited to 8 seats in total. 8 seats for the Anthony family, so that his grandfather and his aunts were excluded from his trial, while those admitted were required to register a day in advance and were warned that a visible facial expression could result in removal. Here's my thing, and we're going to keep going. During a murder trial, or I ain't gonna say all of them, right? Because I skipped out on the one where my baby daddy was charged, and but I was there for every second of everything for my son. And it is normal practice for the judge to let you know that you really have to have some level of emotional maturity and discipline, like Jesus when he went them 40 days and 40 nights, because they don't want you showing any emotion in order to prejudice the jury, right? So that was normal when I heard that. What made my Scooby Doo ears and antennas go up was hearing about all of the emotional breakdowns from testifying witnesses, the family. I was like, what? What? So again, these orders were written with a certain demographic in mind. They were not enforced because the demographic that violated mostly all of these orders were not who they intended to punish. Okay? Ain't that some projecting bullshit? For jury selection, the court furnished what its order had never promised: an auxiliary viewing location outside the courtroom, a functioning overflow room where members of the public who could not be seated inside observed the proceedings on June 1st and June 3rd, 2026. On June 4th, 2026, the first day of testimony, the court took that shit away. No announcement was made in open court. No order was entered or modified, and no findings were made. Public access was thereafter confined to the seats inside. Nor was the elimination a reaction to anything that occurred at trial. As early as May 25th, 2026, the public information officer had advised inquiring journalists in writing that there will be no overflow room during the trial. See, he fucked up. All they dirt and they fucked up. This, although the county's own media request intake form listed overflow room access. So your intake form gave people the option for an overflow room, but you already knew that you weren't going to be offering one, according to Steve Stoller. Among the accommodations that could be requested, when former prosecutor of Dallas, Thelma Anderson, asked the court for an alternative viewing location, there was no way even to file the request. The county's electronic filing system had no category for a courtroom access request in a criminal case. So the request was routed by email to the court coordinator and on to the public information officer, and it was denied outside any judicial proceeding. On June 5th, the public information officer confirmed in writing there is no overflow room. All right, so we're going to start another one. Okay, we're going to start another one. We're going to start another one. We're going to say if y'all just, if y'all just don't like me or something, I don't know. We're going to put it at all the colors cuz I'm fair. Okay? We got another goal to open the chat. 10 super chats with all the colors. 1 hour. Again, if I ain't giving you no motherfucking super chat. I want to talk. Okay, well, you know, buy the 99-cent membership. Y'all don't want to do that either, but you want to talk? Shoot a bitch a cash app, okay? Okay. Um, but the likes don't even match the looks. So we definitely not gonna just open it up. I'll leave it to the supporters of this channel to speak. Okay. F, the fuck shit. F stands for fuck shit. The pattern is visible day by day. During jury questionnaire and voir dire, June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, that room was eliminated. And on every documented day of testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witness was testifying and vanished precisely when the evidence began. So, if they really were trying to protect the identity of the jury, why would y'all have overflow room and all this access for people to actually see them, hear their answers to questions, see who y'all pick? You know what I'm saying? They were able to see all of that. But then when it comes time for the trial, y'all say, I hate you, bitch. You know what I'm saying? Like that don't make sense. That does not make sense. Look at me, steady trying. I'm steady trying. Hold on. Because I like giving motherfuckers options. You know what I'm saying? Because you never know what's going on. I like to have options. So, hey, why not? Right? I'm trying to get y'all the link to the Twitch. I'm going to give y'all the link to the Twitch in case y'all over on YouTube and wanting to say something. Okay? I'm going to get y'all that link. Here you go. So yeah, if we can keep the membership link and the Twitch link going. Yeah, keep you say, yeah, come on over here. Keep you say, come on over here. She holding it down for my girl Flip Mode. Okay, she holding it down for Flip Mode over there. Yeah, they got it. I done gave it to them, Keith, you okay? I done gave them 15 ways to motherfucking talk. Okay, Louisiana Succulent. Okay. She say, let me through this bitch. She done resubscribed for 2 more motherfucking months. Let's go, let's go, let's go. Welcome to the Sonya Quarters of Twitch, baby. Okay. All right. Let's go. Yeah, they ran a very tight program. Yeah. Yeah, they did. Bitches. They so motherfucking superior that these bitches got the con cloaked. Why you can't just be bold in your bitch assness, huh? Huh? Why y'all gotta cloak yourselves? Why you gotta act like you one way and be another way? That's cause y'all warring with people who ain't at war with y'all. What kind of pussy shit is that? Who the fuck keeps warring with people who are no threat to them? Who the fuck keep warring with people that they fucking with? That's weak. Ain't no such thing as white supremacy. When it comes to these nationalists, because our white people ain't like that. when it comes to these nationalists and heritage people and all that, these ignorant motherfuckers, they stop calling them white superior. Fuck that. That ain't no white supremacy. That's the actions of a weak, scary, snakish, evil, sad, sorry sons of bitches. That's what they is. Okay? And all I'm gonna ever do with them hoes is criticize, criticize, criticize. Okay, let me finish reading. Let me stop. Day by day, the accommodation existed only while no witnesses testified. That's what we already read. All right, so they show right here the date of the proceeding, public access as administered, and then they have an evidence key telling them where they can find these exhibits for these claims. Okay. And that continues on to page 7. And it's basically just a chart of everything that we had just read. All right, we're on the G. God awful disgrace. Oh shit, what did I do? Okay, there we go. My bad, y'all. Don't get dizzy. Stay still. All right, there we go. G. Something about G. It fucked me up yesterday. Hey, now with the likes matching the views. The excluded public. The exclusions that followed were repeated and concrete. Jacqueline Young traveled from North Kakalaki, and on the first day of testimony, she found a line roughly 80 to 100 people, from which only about 27 were admitted. Tiara Allen flew in from Arizona, observed jury selection from the auxiliary viewing room, was told on June 4th that the room had been eliminated, and was excluded from the courtroom on June 4th and June 5th. Bridget Smith attended on June 1st, 4th, 5th, and 6th, and confirms both the roughly 27-seat public cap and the elimination of the outside viewing location once testimony began. Kiara West was turned away on June 1st on a purported jury members only rule. What? And was physically removed from the courthouse on June 6th because of the expressive content of her clothing. I get the clothing part because, I mean, hey, y'all, that's just court. That's regular court. If it ain't like that in y'all courtrooms, tell me where you from. Thelma Anderson, former district prosecutor for Dallas County, was excluded on June 4th and on June 5th. On June 6th, was seated only in mid-afternoon, and substantial portions of that day's proceedings had already passed. Throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain these bullshit ass restrictions. The unrecorded agreement. This the bullshit. Right here. Right here. This it right here. This is what Yella Beezy, Marquise DeAndre, GRC, Yella Beezy, Big Crip Conway. This what you need to be worried about, my dude. Okay? This what you need to be worried about. Y'all be so worried about the alleged gangsters in the street. The fuck y'all gonna do about the ones in the courthouse? Let's read about how this gangster Toby Shook played like he was a part of the regular people gang, the justice gang, the patriot gang, the constitutional gang, to get in on this money from this client, only to set him up with his other gang members. H, the unrecorded agreement. The defense tried its case under that limitation in reliance on an understanding reached off the record. Number 16. The same off the record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, the lead prosecutor, Bill Fucked Up Worski, proposed that the parties try the case clean, based only on what happened under the tent that day, even though they still won't fucking release what really happened under the tent that day. Even though they go with some 4K footage and fuck that up, that's all they want to talk about, though. With neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. I don't understand why the fuck this included Hunter, maybe an attorney, a book, somebody with some. I ain't in school yet to be a paralegal. I don't know. Can somebody please help me to understand how Hunter is protected under these? Yeah, the twins. Read it. It's right there. It's right there. Please, somebody help me to understand how is Hunter Metcalf protected throughout this whole situation? We already read the details of the gag order. Without him saying the twins, he just covered everybody. You can't talk about nothing. Okay? But here, in this gentleman's agreement, this covered both of them. I just, I, I'm ignorant to this. I am. So I don't understand that, and I'm questioning it. But anyway, the terms were negotiated in meetings and calls on May 5th, May 8th, and May 11th. And on May 21st, 2026, the parties presented the understanding to the court itself in chambers off the record. Roach, why were you okay with this? I thought the judge position is to be a referee, to be the interpreter of the law, right? To make sure that the game was clean and that the rules were that they colored inside the lines. To avoid media reporting on bad act evidence, the understanding was memorialized only as a deliberately generic motion in Lyman, hand delivered to the court on the first day of trial. It does not appear on the public document. So because they didn't want media talking about the bad acts, they made sure that it wasn't ever on record. It wasn't on the docket. From that point forward, the defense tried its case under that limitation at every stage in reliance on the bargain. And voir dire on June 3rd, the defense did not explore with the panel the themes of the decedent's character and aggression it otherwise would have developed. In its opening on June 4th, it introduced none of them. Through the state's case on June 4th, 5th, and 6th, the defense allowed the state's student witnesses leave the stand without confronting them with their own recorded statements to police. What was their recorded statement, C-Val? Well, here it is. That Austin Metcalf was, and they're quoting him, kind of like the aggressive guy on the team. That he, another quote, got triggered. That Austin and Hunter, this is the quote, Austin and Hunter, they're not going to let you disrespect them. that, here's another quote, if Austin is about to get in a fight, you can tell. And that he could be, quote, a bit aggressive at times, unquote. And an abundance of caution even narrowed the questioning the understanding permitted. My thing is, so the defense couldn't talk about Austin and Hunter, but the prosecution could assassinate Karmelo's character? Make that shit make sense. The defense designated no experts, foregoing a neuropsychologist prepared to explain how Karmelo's epilepsy affected his perception of threat, and a forensic psychologist prepared to address adolescent brain development and the fight or flight response. Because the state took the position that such testimony would breach the understanding. So Bill Worski and 88 Willis told Mike Howard that if he allowed the neuropsychologist to talk about Karmelo's epilepsy and why, because Big Pressure say getting jumped by all them boys ain't nothing. You live to be a pussy another day. But here they had already paid. I'm quite sure that this neuropsychologist was paid because he had to have talked to Karmelo already, right? The state said, nah, man, you can't bring them. It gonna fuck up our agreement. You want to bring in a psychologist to talk about the human teenage body and its fight or flight responses? Now you can't do that either. Now you're gonna fuck up our agreement. I want to see all the people who was all under them comments and shit talking about it was the witnesses this and the witnesses that and what the defense didn't do and what the parents didn't do. What they at now? I need them to be just as loud. All the ones that was hoping and wishing and praying that Karmelo went to prison and some big white Aryan motherfucker butt fucked him. Where are they now? I'm gonna try to control my emotions and get through this. I just want regular white people who know that this is fucked up and you not with this. I need y'all to be loud. You understand? I need y'all to be loud. You know how black women got involved in that women's rights shit, even though our men knew not to play with us? But for the sake of y'all not being respected at y'all houses, we came on that feminist motherfucking movement with y'all. Remember? Remember when all you motherfuckers was being mistreated and black people fought for y'all motherfucking rights? I need y'all to be loud and call out this bullshit. Because silence and that mean you okay with it. And it could be your kid next. They already did this to a white woman in the same courthouse, these same fucking people. It's about have not, and being in or out of their little club. So if you're not in their little club, it should not matter what hue your skin, what's your sexuality, what's your religion. None of that shit should matter. Because when you sit by and close your eyes while they rape somebody else, you better believe one of them times where they feel like raping, your ass is grass. Yeah, let me just shut the fuck up and read. All right. The forbearance had a purpose. The payoff was to come in the defense case. under the understanding as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through Karmelo. Every pretrial discussion presupposed it. The prosecution repeatedly raised the ambiguous aggressor doctrine that matters only in a self-defense case built on such evidence, and as trial counsel has sworn, in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. So I have to stand corrected. When this first happened, everybody was arguing about Karmelo getting on the stand. I kept saying that it was not normal for a murder trial for the accused to take the stand. While I was right on that, what I was wrong about was in a self-defense trial, it is normal protocol for the accused to take the stand. I was wrong. I stand corrected. Okay? It is normal protocol for someone in a self-defense murder case to take the stand on their own behalf. Yes.
Can I go home today?
You don't want to go to the water park?
Oh, I do.
You want to go home because I told y'all to take a nap?
No, I forgot about the water park. Brooklyn mad at me because I broke her box on accident and I didn't mean to.
Did you apologize?
No. You're bleeding right here, Gigi.
I know. I had a bump and I won't leave it alone. Now,
I'm gonna try to apologize.
just apologize. Are y'all taking a nap like I asked y'all to do? Are you really? Are you being honest? Okay.
We were laying down though, but we're playing.
Laying down and playing? Okay, that's the way you nap, huh? All right, well, can I work? Do you mind? No, you don't have to close the door because you're taking a nap. Yeah, if you're in the bushes, go ahead and hit the like. Okay, go ahead and hit the like. I ain't even worried about the goal to open the chat because it's apparent that they say fuck me. And I don't want no Sonya Quarter members touching that goal. I appreciate y'all. I value y'all. Y'all have already financially invested into the platform, which is why you're able to speak freely in the chat. As far as the likes, I'm not doing it today, Lee. Um, you know, if you want, you can just keep dropping the link to the members link. You don't even have to drop the Twitch link anymore. Okay. On Monday, June 8th, the final day of evidence, after the defense had spent voir dire, its opening, the entire cross examination of the state's case, and the first day of its own case, honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant. What? And asserted that defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. So on June 8th, the day Karmelo was scheduled to take the stand, the lead prosecutor, Bill Worski, told Mike Howard, say, bro, you already violated because you said Karmelo played chess. I ain't tell you nothing about it till now. And I'm telling you now because you better not put that boy on that motherfucking stand. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding. So the sheriff ain't know how to enforce the order from the judge, and the judge don't know how to enforce. Baby, didn't they agree to it in his chambers in May? Why he ain't ask questions then? Hello. Oh, okay. I'm at work. Mm-hmm. Okay.
So listen, you want him to come get y'all, and y'all come this way, or you want
Absolutely the fuck not. Ain't we going past me?
you right. I'm tripping. We going that way. Hey, forgot which way we was going.
All right.
All right.
But see, that's just it, madam. This what I've been saying. They do favors for favors. They will lose to win on something else. Yep.
All right, so we getting on the highway tonight, then.
Yeah, that's what you said. So I'm trying to work. If I could just get a couple hours of work in,
All right, later.
that'd be cool. Yep. All right. Y'all, I be trying to teach my family how to give a fuck about y'all and what I do on YouTube and on social media. They be trying. But I ain't gonna lie, y'all. They be like, bitch, you for us. Are you telling us that that you not for us when you on social media? Are you serious? Yeah, they don't be for that bullshit at all. Okay? At all. At all. I swear to God, they don't be for that bullshit at all. I be like, man, I'm doing important work here. Okay? They be like, yeah, that's what you be doing for us. So why you be doing it for them though? Like, who is them? You don't even know them people. I do. They're my subs and they're my members and they love me. Okay? They be like, bitch, don't nobody love you but us. Like, damn. So I really be trying to steal time, man, so I can come and fuck with y'all because I fuck with y'all. Okay? But but my family fucked off, y'all. But anyway. So yeah, Nika, I get what you were saying. So that's what I'm wondering, right? Like, did Toby, and it's really crazy because Toby wasn't even initially who the Anthony's hired. Toby coming on board was something done between him and Mike Howard. And at this point, with what we're reading in this document, I'd be willing to bet that Worski sent Toby to be a part of this defense to fuck it up. Okay, that's just what that's what I think. I am interested to see what kind of defense he puts on for Marquise DeAndre, GRC, Yellow Bee Zip, Big Crip, and Conway. Okay, you want me to drop the link? I'll drop it. I'm trying to see if Toby is going to Amber Geiger, Yellow Beezy, or if he gonna Carmelo Anthony, Yellow Beezy. Okay, I'm just trying to see. Is he gonna handle Yellow like Amber or Carmelo? That's just trying to see that. I really would like to know. Because the way he did Carmelo was shit. You shitting me. And I pray that this child gets a new trial because appellate courts only review what was objected to in court. You want to go home too? Both when I told both y'all take a nap, now y'all ready to go home? Y'all want to use y'all old toothbrushes to clean the floor? Y'all want to just take a nap until your dad comes so we can get ready and go to wherever we going tonight so y'all can get up in the morning and go to the water park? Hmm? You don't want to do that either, huh? Okay, well then what's the problem? So because the empty box was broken, your whole life is just sad now. All the shit in there for y'all to do. The one, break hers. Break her box and then lay down and take a nap. I'm serious. Break it. Go break her box and then lay down and take a nap. My golly George. All right. I'm back. Told y'all my family don't give a fuck about y'all. Okay, I am still Gigi. I am still TT. I am still sister. Anyway, my family would have never let them people fuck me like this. You hear me? I I I know that everybody is taking on the position of not putting any of the blame on Carmelo's parents. As a parent, I have to place some of the blame there. This is your child. This is what you all allowed them to do to your child. But whatever. Play with mine like that. Watch how I'm coming. Accountability. If we started taking it and holding people accountable more, you would see less bullshit happening. Like at the end of this live, I'm going to present a couple of ways to at least try to stop Roach from being able to retire with full benefits. Okay. I'm going to present some channels where we can at least attempt to get him disbarred, which means that he would not be able to retire with Collin County paying his medical and lifestyle for the rest of his miserable fucking life. He's going for something. Something this bitch ass motherfucker want to run for. Baby, I wouldn't let it. Hey, Nika. Hey, Bookie Bud. Right.
The trial, right? Until
Right.
Carmelo trial, right? So this
Right.
the thing, man. It's a favor for a favor, dog. That's why we seeing it like this. It's a favor for a favor. Okay, so let me give you an example of what happened. Um, was that last week? Last week, my partner, my well, it's like my brother, right? He got a
Mm-hmm.
case, but he got a case out of I think it's like Grapevine. I think all of them connected though, right? So he due to
Mm-hmm.
get out probation early, but he done violated a few times. So he called his lawyer and tell his lawyer, like, say, man, for real, like, go talk to the DA and see what's what. You know what I'm saying? About me getting out paper early. So his lawyer called him back and say he gotta pay for it. And it's a favor. When he called him back, he said, "Oh, okay, this your DA, so this DA owed me a favor, but nigga, you gonna have to pay me, basically." You know what I'm saying? So when I say it's like favor for a favor, they do this shit all the time, bro. Like that's why he didn't want it to be known to the public that he was even on that man case. You see what the woman said? What's her name? That used to be a prosecutor. What she say? Oh, I'm calling Yellow Beezy because that's his lawyer. But even when
Uh-huh.
she had spoke about even when she had spoke about all of this, all of this that Toby Shook did, y'all heard her saying like Yellow Beezy better rethink his lawyer. No, she really broke it down the other night on how this shit go. It go like it's way worse in Dallas County. Dallas County just money hungry. Like if you got the funds, then that's the really sad reality that us in Dallas, Texas is living with. And a lot of us could see
And
this
here's the thing though, Nika.
if they said it. If they'd have said Toby Shook was that baby lawyer, we'd have been like,
Everything,
oh, okay, they finna railroad him to let this person go. Oh
uh-huh,
shit.
for yellow.
Yeah.
Mm-hmm.
But
So here the
yes,
thing though,
I
right? You
said it.
can't never a system can never be rid of this because for every coin it's a flip side, right?
Absolutely.
Here's my thing though. How do because when it's beneficial to us, we ain't mad about it. So how do
Right.
we prevent it from happening to innocent babies, our innocent babies that may not be related to us, that we may not know personally? The only thing I can think of is to make sure that we on them juries, to make sure that we somewhere in that courthouse, to make sure that we are somewhere, because here's the thing, they're going to do it for each other whether they know each other or not. The data show that peach people get lesser sentence for equal or harsher crimes than brown people. They ain't got to know them peach people. It's the fact that they peach. Okay? This is why you can go and they can rape all the girls in their family and their grandma and get probation and to have to register as a sex offender for a year and then it never happened. Because that's a crime most committed by peach people. So my thing is for the politicians, for Obama when he sat his ass in there, all these brown skinned politicians and people of authority. Why is it when you get in there, you play by their rules, but you don't make exceptions for other brown skinned people? You not putting nothing in place for your own people. You just be glad that they let you in. And for that, I can't respect it.
But see, this the thing, madam. They don't play by the rules. You get what I'm saying? Like the rules are always
Right.
bended. Like we see all of these hoes, right? And everything. What do you think they got on what's the other one name? Mark? What you think him or they can hold over his head to where he'll sit there and watch this shit play out right in front of him. And he can write all the affidavits. Like we see all the corruption that's happening in that the paperwork,
Once it's
right?
over with.
What do we think is
Once it's
going to
over with.
happen? What do we what do we think is gonna happen though? Like cool, fine. They know they messed over Carmelo, right? That's the most fucked up part about it is he was the sacrificial lamb. You get what I'm saying? But
Uh-huh.
and in their minds, oh, okay, if he get a good lawyer, if he can even afford, their ignorance to their own shit. You see what I'm saying? So okay,
Mm-hmm.
if he get this overturned, what the fuck y'all gonna do to me? They've been doing this shit so long that they have come to the place where they own all this shit. Everybody that they're going to go to is in already in their pockets.
So
That's
look,
the
when I
sad
went, cause
part
just
about our
now when you
system.
mentioned what they could have on Mike Howard, I remember telling y'all that on Twitter I saw a video that he was saying he's a bend over. Okay, so I went to Twitter while you was talking, typed in Mike Howard. Guess what? The first thing came up was this video with him talking about how pussy he was. You want to hear it?
Please.
So what kind of lawyer do you want? Do you want an aggressive junkyard dog who's going to fight for you hard, or do you want somebody who has a reputation as easy to get along with?
Can y'all hear that?
While of course it's important to have somebody
Yep.
who fights for your rights and stands up
Oh,
for
okay.
you. If they are that aggressive junkyard dog, the risk can be that they end up being obnoxious or offensive to judges, to prosecutors, and even to juries if your case goes to trial. And so, having somebody who knows how to walk that balance, who knows how to stand up for your rights and fight for you, but knows how to do it at the right time and how to do it,
Okay,
that
okay. So
walk
I
softly,
I
carry a
heard
big
that, but
stick
I don't know if they
mentality.
have. But madam,
They
pause
have a
1 second.
reputation.
Pause 1 second.
That makes
Okay.
all the difference in the
I'm gonna
world.
drop down and come right back. Okay.
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 And if you go to trial,
Okay. Let me let y'all finish
risk
hearing it.
can be that they end up being obnoxious or offensive to judges, to prosecutors, and even to juries if your case goes to trial. And so, having somebody who knows how to walk that balance, who knows how to stand up for your rights and fight for you, but knows how to do it at the right time and how to do it, that walk softly, carry a big stick mentality, that they have a good reputation. That makes all the difference in the world, in my opinion. I have cultivated a reputation at the courthouses in which I work as somebody who fights for their clients. And if you go to trial, I'm going to give you a hard fought trial, but who's easy to work with, easy to get along with, and reasonable. That ends up benefiting my clients. It's not something where I'm intentionally, being something I'm not in order to get prosecutors to open up and talk to me. But my reputation as easy to work with ends up benefiting my clients. Prosecutors end up. This is crazy.
Okay.
This is where do you want?
So to me,
Aggressive
that's
junkyard
why
dog who's going to fight for you.
that's why they did what they did. I don't know if y'all could hear it all the way, but according to Mike Howard, he's very easy to work with the prosecutors. He doesn't want to offend the judges or the jury. He doesn't want to step on anybody's toes. He knows when it's the right time to defend you and when to do what. So, in my opinion, he didn't want to come off as unreasonable, hard to work with. He didn't want to come off offensive or anything. So he had decided in his little weak puss ass head, Harry Tubman having, he decided that it would be best if he just shut the fuck up, let it happen, and then help the appellate team. That's what it seemed like to me. And in the event that that video is older than this trial, I think they knew that. And that's why I think Worsk and them sent Shook to Mike Howard. Told him, hey, Mike, I'm going to help you. But probably charged him a little or nothing. I'm going to help you. I got you. You know what I'm saying? It to me. Welcome back.
Okay. Um, it's so man, it's the thing, matter.
Nika.
That shit really make me sick to
Oh,
my stomach. Huh? Can you hear me?
okay, there you go. Yeah.
That shit really make me sick to my stomach. And my bad, I don't mean to cuss. I know you monetizing, but it make me sick to my stomach because some of us that just know this judicial system down here, whether it's Collin, Tarrant, any of it, you can really see what done happened. You know, and it's the saddest part about it is um nobody could say nothing. You know what I mean? Like even if the bell was wrong, like what could have been done? They went through every measurement to shut out everything, everything. And
They
I
did.
almost can guarantee you this: the money Yeller done paid. Toby shook, I bet you Mark got some of it and didn't know until he had to tuck his fucking tail and shut the fuck up. I'm sorry. Until he had to tuck his tail and shut up.
You can say what the
Because,
fuck you want to say. Fuck that.
okay,
This shit ain't. We are never politically fucking correct.
okay.
Okay, ever.
Yeah, until
Maybe the
he had to
best
tuck his
commercials for my
tail.
channel is malt liquor and dispensaries. I don't motherfucking know, but I'm never gonna be politically correct the fuck over here because the shit we talking about ain't motherfucking politically correct. Fuck
That's
them.
true.
Curse. Talk how the fuck you wanna.
Until he had to be politically correct. I mean politically correct. Until he had to sit down and tuck his tail, that's when he realized that, oh, that was a part of the money that was given to me.
Hmm. Hmm.
Like all people got to do is pay attention to the pattern. You know what I'm saying? And I'm not saying that this man gonna walk. I'm just saying that the things that are being surrounded is they'll put this right in our face and then treat us like they'll bully us like what you gonna do about it? What y'all gonna do about it? And then they'll try to call out the faults
And that's
of,
the
you know what I'm saying?
yeah,
If they
yeah.
wanted to stop Toby Shook, Roach, or even the prosecutor, they 20 years in. These people 20 and 30 years in the game. You think they came this far to let something be snatched away from them? Nah. They already know what's going on. The sad part about it. That's the most ailing part about it, G. I really hate it. And
But
please,
check
y'all,
this out though,
please don't
Nika.
get me wrong. I'm not saying this man gonna walk. I'm not saying that. I'm just saying that don't be surprised if you see some real life fuckery going on in August. Don't be surprised.
Well, I think at this point we can expect it, right?
Yeah,
But here my thing though. They've been going for, like you said, over 2 decades.
right.
Do you know what they've relied on and still rely on in order for
Yep.
them to maintain their
Yep.
false sense of privacy?
Yep.
On us only talking
On
about it, on us
yep.
only being
Not
emotional, on us
making no
only
moves.
marching, on
Absolute
us
being
only,
emotional.
but not
Absolutely.
being emotionally charged, you
Exactly.
know? But they don't expect us to actually do what needs to be done because
That
there are
yep.
methods that would, and let me tell you, they not easy because I've seen it done. And I
Right.
know for a fact that before they actually give in and do what they supposed to with what you doing, hey, somebody higher up that you going through to do it is with them too. So
Yep.
what I've seen happen is it ain't until it is nationally then internationally exposed that they actually do anything about it. Even if you look back to Emmett Till and things of
Uh-huh.
that nature, Emmett wasn't the first little black boy that had happened to, but it was always kept geographically restricted to certain areas. Everybody didn't know. Once that magazine put that boy on the face of the cover of that and the whole world saw what America was doing, it wasn't until then that America started doing it sneaky. Because they ain't even stopped. It wasn't then until they just stopped being so bold with it. Okay. So to me, it's time for us to start doing fuck Mike a pussy punk bitch. That's from Sleepy Lounge Drive.
Real shit, sleeping. Real shit.
Yeah. So to
And
me,
and it's
Nika, that's
go ahead, I'm sorry.
go ahead, go ahead.
I was gonna say this is the craziest part about it, right? Um, if and I don't know if people listen to the lady Thelma. I think she was a prosecutor in Dallas.
In
And and
Dallas,
and
yeah.
and look, I can't remember if she said she left, but she kind of explained it where the people that's for right, they'll get out their way because I don't think we understand how deep it goes. You get what I'm saying? Like we just
Oh, I
seen it
do.
happen with we seen it happen with Jasmine. You see what I'm saying? Like they cheated her out of her votes. You know what I'm saying? So it's just man. All that shit political. And if we don't stand up and let them motherfuckers know that we more dangerous together than you know what I'm saying, us being emotional and just talking about that shit, then they gonna keep doing that shit.
Exactly. Exactly. And that's all
And
I'm
people gonna
screaming.
keep it.
I'm
The ones
screaming
that we
to my
need in
my
office,
neighbors.
the ones we need in office is going to keep running and tucking their tails, because when it's time to get behind them, motherfuckers scared.
We don't. Right.
We don't do it. That shit weak, dog.
Well,
That shit weak.
as y'all neighbor to the left of y'all, to the right of y'all, however which way you looking at it, say, bro, I'm offering. I'm offering favor for a favor. I don't mind coming to fight with y'all. All I ask is that when I'm trying to get C Murder and my baby dad out of jail and shit, y'all come fight with me. That's it.
Straight
I
up.
don't mind putting in the work to help another community because we got it's the only way it's gonna work. Is if we caravanning from Louisiana to show up too. If
This
when we
shit
in
goes so
Louisiana
deep.
trying to fight
This
these
shit
motherfuckers, y'all show up too.
this shit goes so deep to where y'all they people wonder why a lot of these motherfuckers got houses here, there, and everywhere, because they controlling all that shit.
Yeah, because all they got to do is have a residence
All
in
you
whatever
come on,
area they
man.
meet the qualifying. Come on,
And they put us in these
come on.
red zones. They put us in these zones that we allow them to put us in. We allow them to put a color on our zone instead of creating a zone that's for us. You know what I'm saying? Like that's what that man.
Absolutely.
That shit got me
And then
fired up.
the
When I
fucked
listen
up
to that
part,
shit being rigged, that shit fired me up, dog. Like, damn, it's fucked up, bro.
the fucked up part, Nika, is it's always some motherfucker that look like us
Uh-huh.
that be right there with the shit.
Come on, man. Shit
Always.
crazy.
I can't think of a time where it wasn't somebody that looked like us involved that helped them bitches do what they do.
Come on, man.
So that's what I be saying. We are not war ready. You talk about how weak they is, but guess what? It's that they scary. And old law say a scared motherfucker will hurt you.
Uh-huh.
Okay? So this is
Uh-huh.
why they always motherfucking hurting us. Because that a scared motherfucker will hurt you. And it's just that simple.
Straight up. Straight up. That's real. I
They
just
are afraid. They are afraid of their numbers going down. They think about it, Nika. With no motherfucking qualms, we the minorities, right? They love to holler minority this, minority that, minority this. These motherfuckers are afraid of being called the minority.
the
That's
minority.
what's fucking
Like,
sick.
like Jeff, so Jeff, he can't he can't even sit in the little wealth that he has accumulated from his son's demise or passing, that he's still calling out, you know, the shit that he envy about us.
Let me tell you what was a shot that he threw that I don't know if everybody caught it. When he said that he was an Indian and that they had their cards,
Mm.
that was a whole nother shot. What he said
Mm.
is, you dumb, stupid motherfuckers don't even know
Mhm.
who y'all are. And my
Mhm.
ancestors been fucking over y'all since the beginning.
Since the beginning.
Whether all the Metcalfs are related or not, what we do know to be fact and true is that the Metcalf name is a fucking British name.
Mm.
So you may not be kin to all of them, or you may not know you related to all of them some kind of motherfucking way. You can act like it wasn't such a thing for back in the day when y'all first brought y'all asses over here for a motherfucker to have 20 something children if you wanna. And they brother have 5 and the other one have 10 and the other. Yeah, you bitches is related. You bitches is related. But the thing of it is, all these people in powerful positions, they know our truth and we don't. And they play
Mm-hmm.
on it. They depend on it.
Yes.
They rely on that. They will spend billions of dollars
To keep
playing
it keep
to
us away
our
from it. Yeah.
entertainment and
Mm-hmm.
shiny new nickels that ain't worth a
Mm-hmm.
shit that they
Mm-hmm.
have. Man, you gotta look at the head of the Heritage Foundation. This man entire academic career was him researching niggas.
Hmm.
That boy went got a doctorate and all he wanted to research was niggas. Why? Because in order to go to war with somebody, you got to know who you warring
Got
with.
to know who you warring with. Come on, man. Say that shit.
But before
And then
all else, you got to know who the fuck you are.
straight up. Mm, mm, mm. Mm, mm, mm.
We had all that. I know it's harder to find that now, and that ain't what we was taught. I don't give a fuck how much college education you got. Some shit they do not teach in their institutions. And that's one of them. All we know about black greatness uh of the past was Tulsa. Tulsa was not the this was the way of life. These people just start coming up. These people just got this bold when they got here in the 18th. Listen, baby, I've shown y'all the old newspaper articles where they was hollering about when they get 10,000 of us over here from over there, we gonna start expanding. They didn't have the numbers to move like they wanted to until the 1800s. The grandma that helped raise me, her mama and daddy was born in the 1800s. So it ain't that far away. Wasn't that long ago. All the shit
Right.
they doing now is that's just the same fuck. That's their initial plan. They just now implementing it, and we just letting them. And it's for that reason, Nika, that I don't blame these people. Fuck. I mean, how can we? Because if it was us, why wouldn't we do what they do? That's what you're supposed to do in a position. They're doing what they are supposed to do. We the ones not aligned correctly. We the ones can sell grandmama house. We the ones that sell out for any old motherfucking thing
Come on
because
now.
we don't value nothing that we can't see money from.
Come on now. I'm gonna tell you something I went back and watched the other night that I had to really watch it and process it. They cloned Tyrone.
Man, I think we should have a movie night on
Yes.
Twitch. And
Yes. Ooh.
yeah, when I was watching something about the chicken, Chick-fil-A chicken, and a black scientist had broke that shit down. He was like they had 50 chemicals. 40 of them were man-made in their recipe cuz he say he went to Chick-fil-A at when they opened up that morning. He said and he was so shocked that all three lines was wrapped. So he went in and ate and he decided to stay to do a little experiment. That man say he ain't leave up till like 3 something p.m. and all three of those lines ain't never give in. He said something gotta be it got to be something. Ain't no chicken that good. So he bought
Mm-hmm.
some to go and he took it to his lab and he tested it and they had 50 chemicals. 40 of them were man-made chemicals. So I thought they cloned Tyrone, of course, when I seen it. It's like, yep, they're
Man, they
doing it.
clone Tyrone is like man, and it take you through your history. Like you realize that. And I was wondering why my great grandmama had tripped out so bad on my mama the first time she relaxed my hair. I'm talking about she
Oh
tripped
yeah,
out.
absolutely. Them chemicals, man. The
It did
motherfucking
not play
chemicals,
with them
man. And
chemicals,
and now
boy.
look at it. Now you it was so crazy though, is that fucking relaxer class action lawsuit done been out for so long. It done been out a while now. How many of y'all? How many people still get relaxers?
Mm. It's a lot of folks still get say, and I'm the most tender headed. I say I'm the most tender. Yeah. Oh my goodness. I used to say, I'm too tender headed. I gotta. Man, I ain't had a relaxer in so long, in so many years that
I
I
think for
forgot my
me since 2012, 2013, something like that.
say I forgot the texture of my hair. I forgot that when I straighten my hair, it looks like I got a head full of weave in my hair. It looked like I got, you know what I'm
Straight
saying?
up, because but Nika, think about the night before Easter. Baby, when we was
What?
little, you got your ass in that kitchen. They put that hot comb on that motherfucking
With
stove.
that blue
They got that
magic?
goddamn grease.
Come
Man,
on
look at
now.
here, look at here.
And you had
See,
the
but
prettiest,
what's so
puffiest
fucked up though,
curls.
Nika, is check this out. I was telling they did this when he came over here with that old bullshit trolling in the chat or telling on himself, whichever one it was. I said anything that can't be replicated is automatically valued a little more, right?
Mm-hmm.
Black people and our corals, we're the only ones with them.
Yep.
Irish people got a little corals, but they still ain't like ours.
It still ain't
We
like
can get
ours.
to that hot comb and we can straighten our hair, but it ain't shit nobody else can do to make their hair ours.
Mm-hmm.
So what they did was they have taught us that our hair in its natural state is something that needs to be fixed, all
Mm.
because they can't have it. All because they can't have it. Hey, beauty
Beauty
child,
chair.
she done
Hey,
dropped
beauty
down.
chair.
I've had
I,
locks in my hair from 2014 to 2019 and 2023 to present. Yeah, this is my second go at them too. But I ain't had
I,
a
um,
relaxer. I've been natural since I think like 20, like I said, like 2012, 2013, something like that.
I think I'm ready to, and I
Lock it
think I
up.
want to do the real little bitty ones.
The sister
Mm-hmm.
locks.
Mm-hmm.
That's what I wanted. But then when they went to telling me it was gonna cost me 12, 13, $1,600 to get them, and I know how to lock my own hair, I
Yeah.
said I'd be fucked.
Oh yeah, see, I hadn't even
Nah, I'd be
researched.
fucked.
I hadn't even researched. Cause I think I'm still loving the fact that when I straighten my hair out, even if I decide
It
to
could look like
wear it in a ponytail with just some regular grease and water, I'd be like, yo, how did I ever get away from my little ringlets? Like, like the curl pattern is so pretty. Like it looked like, I feel like I look like a mixed girl. I'll be like, yo, I never knew that the texture of my hair was like this.
say Nika, when I went natural the first time, I cut my hair. I wore a fade, right? So my daughter, my oldest daughter, y'all know she coon ass, right? She they mix with this, that, and the third. So of course her hair is the hair of what mixed children would be, right?
Mm-hmm.
Baby, when she's and I loved it because all I had to do was wash my face and take that same towel, put it back under the faucet, and rub it across my head. And my motherfucking waves went to wave, and she was like, "How your hair get like that, girl? Don't play." Yeah, you
Mm-hmm.
ain't even know. You didn't
Mm-hmm.
even know. It's called ether, not hair. Okay, sleepy long
Okay.
ride. It's called ether, not hair. We have ether. That's why they want it. It connects us to home and it allows us to download information.
Facts.
Okay. I
Facts.
stand corrected, Rob. You ain't lied. My
Facts.
bad.
But okay, and I'm gonna let you get back to this, but I just want to know because I was definitely gonna send you this and say we need to go down through this because I don't know if and I'm sorry y'all I'm a jump down and we're gonna get right back to it. But did you know Jamal? What was his name? Jamal. You know he had the cosmic School of Intelligence. He was on YouTube. He used to be a rapper. He out of Atlanta. And
Mm-mm.
he was teaching okay, so we're gonna have to go down through there because they locked him up because his kid's mom said that he were saying the kids, which
Oh, I do remember that.
okay. So do you know they are doing a whole special on him on the ID channel? Um which is the crime channel, and they are saying that a lot of his members, they saying that he was running a cult, and a lot of his members has gone missing, and yes, a lot of people speaking out. So we're
What
gonna
the
have
fuck?
to, yes. So I'm sitting. I've been checked out of TV. So I'm just the TV actually watching me one day, and I'm steady looking at this little picture in the bottom of the TV. I'm gonna have to send it to you. I'm steady sitting here looking at this picture, and I say, "Well, dang, that look like Jamal." And then it kept saying "cosmic of intelligence," and I'm saying, "Well, what? Wait, why would he be on the ID
Rasha
channel?"
Jamal, the one who caught that child endangerment charge.
Rashad
Rob, hit
Jamal.
the fucking panel. What the fuck?
Rashad
Rob, buy the
Jamal.
99-cent membership, Rob. If I say we playing bingo with your ugly ass, you gonna want to get up here
Yeah.
and play for $50
Dang,
a
at this
hand.
point, I gift him a membership. Like, what in the
Okay?
world?
He steady texting.
99 cent ass. He'll be up here buying 10 numbers and shit.
Girl, listen. He always sweet babe. Always get mad. Rob always want to play for $5, $10 a goddamn ball. Now he over here texting me instead of hitting the panel or getting a membership.
Yeah, but they have a whole special that's about to run on this man on the 14th of July, talking about this man. Now, let me be honest. Petita said that if he didn't, that he knew why he was still in jail, and if he did not um give do what they wanted him to do, that he would be facing this. She said this years ago when he first went to jail, that if he didn't confirm or what is it called,
Comply.
comply, then they were going to publicly take him down.
Execute him. Mm-hmm.
Yes, and that's exactly what they're doing. They
You
said
got to
this
think
man,
about all the shit that they come back with later and say, yeah, we did that. When it
yeah.
comes to even the Vietnam War and how they played the American people to justify them going into Vietnam. Now they're willing to say, "Oh yeah, we lied. Yeah, we act like they bombed us." I can't wait until enough time passed for them to tell the truth about 9/11.
Exactly, because I know that's what made me stop watching. Well, nah, it wasn't 9/11. Oh yeah, yeah, 9/11, because 9/11 was before Katrina. 9/11, I was
Mm-hmm.
out of there, and then Katrina just took me all the way out. I was like, you know what? I was still trying, and I said, nah. Once Katrina happened, I said, nah, I'm done. I'm done. So I don't watch the.
Look how
I
long
don't
it
watch
done
it.
took for them to come out with the fact that they broke the dams.
The
They just
levees.
now coming out. Yeah, they just now coming
Well, you
out
know
with
that.
them facts.
That I think that that little series was them trying to cover.
Hello, Rob.
Hello, hello, hello. How you guys doing?
How is that? How does thy do?
I do very well. I do very well. Can you guys hear me?
Yeah, I can. I don't know what happened to Nika. She left when you came.
Uh, she get shy. Hello? What the hell?
Yeah.
Oh, okay. I'm seeing.
What?
What's up, Alicia B? Oh, yeah. They did all kind of wild because he was carrying guns with him everywhere he go. You know what I'm saying? They was he used to always talk about rebelling against them and all that other stuff. It took them a minute, but they finally got. And then I believe that they sent agents out there to make his name look bad, so people can turn their back against him, so he
Yeah.
can be forgotten in jail. But it's a whole lot of people still holding on, and they gave him the
And
worst
now
crime.
Nika say that they actually now are reporting that the people who was following him are now missing.
Yeah, probably the major ones that were keeping his name alive. Hey, dang,
Yeah, they had to get rid of them.
my mama will call me when I get on the phone.
Oh
Oh
shit,
shit,
Rob, what the
Rob, what the
fuck?
fuck? I'll call you back.
We just gonna mute Rob until he get that together because he hurt my motherfucking ear. Rob, let me know in the back chat when you got that shit together, okay? Y'all wanna try it? Let's take Rob off mute. Rob, okay. Rob is now gone too. Okay? Rob is now gone too. All right. So I guess we'll try to get back at it. Okay. So just to remind y'all of where we were, um, they're talking about the agreement made between Toby Shook and Bill Worski on the telephone. Okay. It's answering all of the questions that everybody had on why this and why that when it came to the reports that we received about the trial. And because I'm childish, we're gonna run another goal just because. Okay? We're gonna run another goal just because. Because 10 super chats in an hour to open up the chat with all the colors. Okay. All right. The only way we're going to open up the chat without meeting those goals is if the members say, Madam, let them in. If y'all say, let them in, we will let them in. All right. Let's keep reading. When Nika and them come back, we can finish them conversations. Everything cool? Y'all ready? Let me put this game down because I ain't gonna lie, y'all. I did. I started playing the game. I started playing the game once I ain't have to read no more. All right, let's go. On Monday, June 8th, the final day of evidence. After the okay, we read it. Yeah, they never contemplated a testifying defendant and asserted that the defense counsel had already opened the door by mentioning and opening that Karmelo played chess, a position the court itself rejected. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding, an understanding that throughout the months the defense relied upon existed on no record because it had been reached and presented to the court off the record, and that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. Allotted only 10 motherfucking minutes, the defendant elected not to testify. I would have too. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state witness. Okay, so now that I'm saying that part, conduct a different. So if y'all remember, I don't know how many of y'all was watching the content creators that was in court the day of voir dire or jury selection, but I think every member of this seated jury said that because that was a question that they asked, and from my little one trial experience, that was they asked that then too. Um, would you give negative weight to a defendant that didn't take the stand to testify on their own behalf? If I'm not mistaken, and I'm gonna go look at Queen Sheba live again and Neek at Nights, I think everybody that was seated said that yes, they would have a problem with a defendant that did not testify on his own behalf. So the prosecutor knew at that time that they weren't going to allow Karmelo to testify, and that, hey, stop that, and that if he did, they were going to talk about whatever they wanted to about his character without them being able to speak on Austin, and for some weird ass reason, Hunter. Hmm. Okay. Deliver a different opening or recross the state's witnesses. And at punishment, the defense case was reduced to 3 approved questions of the defendant's mother. Hello? Pre approved questions from Mother Anthony? The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately. Exactly as the lead prosecutor had described on May 11th that the agreement would operate. Exhibit 10, the state's punishment presentation will be confirmed by the reporter's record. Go out the carport door and don't run in and out of my house. And go to the back so I can look at y'all out this window. Hold on, y'all. Excuse me, beautiful little brown, beautiful little innocent, sweet little babies. Did y'all hear what I said? What did I say? What did I say? Stop. Put it in trash. Y'all chewing on water bottle tops. What the? Put it in the trash. Put that in the trash too. Put it in the trash.
Spike will eat us.
Go ahead because it's 6:50 now. Y'all don't have much time before it's too dark. Before it get dark.
On the back?
Yeah, go somewhere back here where I can see y'all. Y'all don't have to go in the fence part with the chickens and shit.
Oh.
But y'all be in the back of the yard so I can actually see y'all. Okay, my apologies. I'm back. The state thus performed the bargain at punishment the day after denying that the same bargain covered the defendant's testimony. I'll read that again. The state thus performed the bargain at punishment the day after denying that the same bargain covered the defendant's testimony. So after they told Karmelo that, girl, they ain't Big Mo went to no fucking sleep. You hear me? They ain't Big Mo went to sleep than the man on the moon. But that's okay. Because we supposed to travel tonight and do the water park tomorrow. Meet him and my brother. When I tell you I am going to be checked out, this is all on him. I must be just going to drive. Got to be just going to drive. And look good in my little bathing suit at the water park. Because I ain't doing it. Mm-mm. I told him and my daughter, y'all punk ass parents had these children that play with y'all. Okay. And then y'all send them over here to me. And y'all already know how I raised her. Two completely different styles. So I do a lot of threatening. I do more threatening than anything. Jesus. In the end, neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only term repudiated was the one most vital to the defense, the defendant's own testimony. I don't agree with that because I think that with the state asking each one of them children who the aggressor was, who the provoker was, I think that that was them trying to show bad acts or bad character of Karmelo. So to me, that would have been a breach in the agreement in itself. Carmelo Anthony was necessarily a witness to what happened under the tent, under the understanding as the state itself had repeatedly described it. He would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on his own perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the Vador, opening cross examination, expert designations, or decision framework that had followed from the understanding. Because Mike Howard is a pussy. I smell, I smell pussy. You know what I'm talking about? I need that clip. I need that video clip. So anytime we talk about Mike Howard, we can just play that clip. The trial itself was run at speed. At the May 29th conference, the court announced its intention that the defense began calling witnesses immediately upon the state's resting so that no trial day would go unfilled. Hello? Yes, brother.
I'm gonna see. I'm gonna have to try to switch it out in one of these other states. I mean, maybe in what's the name or something. I don't know. This shit crazy. But I got one.
Okay. Tell the people, say hey.
Tell who?
Tell the people of the Sonya Quarters of the internet, hey.
Oh, hello. You ain't got no barbers out there in Dallas?
Big Roy out there.
Oh yeah, I need a barber. I already tapped in.
And I ain't tell these people where I was going. Get the fuck off my phone. Good googly move. Where was I at? If y'all heard that, y'all know where I'm gonna be. If y'all got children, y'all want to bring them to the water park tomorrow and meet and greet, bring them on. We'll be at the water park tomorrow. Oh shit, I might need to just schedule it, right? Like he got to deal with the girls because I'll be doing my meet and greet. Okay. Anyway, the trial itself was running to speed. Okay, calling witness immediately to say resting, so that no trial day would go unfilled, including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call Karmelo out of order. The state rested midday Saturday, and the defense began its case that afternoon. The repudiation of the parties' understanding, described above and set out fully in part below. What is that, 5? Erupted on Monday, June 8th, the final day of evidence, when the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify. The court allotted the defense 10 motherfucking minutes to counsel a 19-year-old through it and denied counsel's request for additional fucking time. So the court knew up until June 8th that Karmelo was going to testify on his own behalf, which means that Mike Howard, pussass, had been prepping him for an entire year. On the day of his testimony, they said, remember our agreement. He can't say this, he can't say that, he can't say this. And if he testifies, then I'm going to come up there and I'm going to say this, that, and the third. To which you cannot on cross say a fuck thing about what I told you and we agreed you could not say. So you got 10 minutes to go let your client know that that's what's going on and prepare him to testify. Say, Judge, can I get a little more time than 10 minutes? Hell no. 10 minutes. Yeah. Get down and lay down. Shh. The defense rested that day with their pussy ass after the shortened session, and the jurors were sequestered overnight in a hotel, informed that if they did not hurry the fuck up on a verdict on Tuesday, they wasn't going to be able to go home. On Tuesday, June 9th, 2026, the court delivered its charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding this child guilty of fucking murder. The punishment phase, evidence, argument, deliberation, and the rejection of sudden passion was then completed, and the 35-year sentence imposed before the day ended. The sequestration and deliberation chronology, widely and publicly reported, will be established at the hearing and confirmed by the reporter's record. Who the fuck is the reporter, and why the fuck should we trust them? Why should we trust the court reporter? After the verdict, the sealed file, the missing record, and the televised defense of the closure. The secrecy outlasted the verdict. Trial counsel withdrew on June 10, 2026. Appointed appellate counsel was then replaced. The present counsel was substituted in on June 23rd, 2026. All while the 30-day deadline for this motion ran, the reporter's record. See, Nika, this is why I said somebody was scamming. Was completely untranscribed, and the pleadings and case file sat in Roach's chambers rather than in the district clerk's public record, sealed by an oral order. They don't want to put nothing on record. He just said. Roach said, can't nobody get it. At a conference on June 29, 2026, the court advised that the entire court file had been sealed by oral order and conditioned counsel's inspection of it on an agreement not to disclose what he observed. A condition counsel could not give, leaving the file available only in Judge Roach's chambers. So they told Karmelo's appellate team of attorneys, if you want to look at this file, you got to agree that you ain't never seen it. You got to look at it and act like you never fucking seen it. Counsel say, nah, I ain't going to be able to do that. They say, well, then, bitch, you can't see it then. Oh, shit. Where are the patriots? Where are the people who stand by the Constitution? Do they hate Karmelo more than they love the Constitution? The patriots should be all over this. What the fuck? 2 days after imposing sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks maybe he should have at least audio streamed or something so people could hear it, and explaining that he declined to do so because people are going to distort whatever happens. So what's the point? In a written statement to Fox News, of course, Roach added, now that the trial is over, it is important to me to provide transparency after the fact. Let me be transparent after the fact. My version of transparent anyway, because I still said I'm not sending these files to be transcribed. I'm not sending them to the district clerk. And you can't see them unless you agree to act like you ain't see them, and you got to see them in my chambers. But by all account, I'm now being transparent. And in a public letter on June 17, 2026, we read it. He thanked the other judges of the county for adjusting their own documents dockets to accommodate this trial. At minimum, raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. So if all the other courtrooms was empty, why couldn't they be overflow rooms? If Roach and the commissioner's court had in fact ensured that the entire courthouse was designated solely to the Carmelo Anthony trial, then please tell me why more than 27 people from the public were not able to come in that courthouse. Hmm? Didn't the commissioner's court pay for extra sheriffs? Extra security? Because the reporter's record of the trial has not been prepared, this is as of 3 days ago, the official court reporter has advised counsel that no portion of the trial has been transcribed. And because the case file has been held in Roach's chambers rather than in the district clerk's public record, the recitation above is drawn from the indictment, the court's charge, the public docket, the court's own orders, and public statements, the attached affidavits and declarations, and counsel's knowledge. Defendant will offer evidence at the hearing in support of the grounds timely raised herein. What's crazy is Judge Roach is the one who get to decide if he get to have a hearing. Procedural background, timelines, and jurisdiction. On June 9, 2026, a jury found Karmelo guilty of murder, and on the same date, the court imposed sentence in open court, assessing punishment at 35 motherfucking years confinement in the Texas Department of Criminal Justice Institutional Division. My Lord, my Lord. All right, on June 4th, 2026, the trial court signed the certification of the defendant's right of appeal. Although that certification issued before the verdict, the judgment of conviction was rendered and sentence imposed on June 9th, 2026, and the notice of appeal followed. So they knew on June 4th that he was going to need that appeal. Oh, shit, wait a minute, I ain't even see you over there. What's up, nurse? Wait a minute now, I got to find out how to get some goddamn noise going when y'all over there on Twitch showing love. I don't know how to do that. I'm gonna have to figure out how to do that, okay? My bad, P. My bad, P. Welcome home, P. Something told me to come over here and look. All right.
Why we was outside and we seen another one. We saw another dead chicken. Yeah, we saw two.
I told y'all he killed 2 of my chickens.
Why he did that?
I don't know.
It stunk. It had flies all over it.
Is my door closed that y'all ran back in through? Are y'all in or y'all going back outside? Okay, the next time y'all come in here, just take baths. Don't go back outside. On June 10th, 2026, the defendant filed his notice of appeal, and the appeal was docketed in the Fifth Court of Appeals as cause number. Oh, I need to screenshot that. Let me screenshot that so we can start fishing for those documents. It won't let me screenshot. Leisha, screenshot this for me. Somebody, screenshot this right here so we can have the appeals court cause number. Got it? Cool. On or about June 11, 2026, after the verdict, the sentence, the certification of the right of appeal, and the filing of the notice of appeal, the presiding judge, Roach, gave a televised interview concerning this case, which aired on WFAA TV, Channel 8. This motion is timely under the Texas Rule of Appellate Procedure 21.4, being filed within 30 days after June 9, 2026, the date the sentence was imposed in open court. The court retains authority to consider and rule on this motion. Voice access. No, I don't want no motherfucking voice access. I ain't asked for that. The hell? The court retains authority to consider and rule on this motion through the 75th day after that date. And a notice of appeal, if any, does not divest the court of that authority until the appellate record is filed in the Court of Appeals. Because sentence was imposed in open court on June 9, 2026, the 30th day to file this motion is July 9, 2026. And the 75th day falls on Sunday, August 23rd, 2026, subject to Texas Rule of Appellate Procedure 4.1. Karmelo requests a hearing and ruling no later than Friday, August 21st. That's my grandbaby's birthday. Hey, fam. What's happening? Welcome home. To avoid any dispute over Rule 21.8's deadline. Karmelo is presenting this motion within 10 days of filing, as Rule 21.6 requires, and contemporaneously requests that the court sign the attached order on presentment and set the motion for an evidentiary hearing so that the parties may present evidence and the court may rule within the time Rule 21.8 permits. Contemporaneously with this motion, defendant is filing a motion to recuse the presiding judge. Okay? He not even going to recuse himself. He should have just stepped the fuck down. You did what you needed to do. Okay? Now step down. Because Rule 18A of the Texas Rule of Civil Procedure governs recusal in criminal cases, see Arnold v. State. Karmelo requests that the evidentiary hearing on this motion be conducted by the judge presiding after the recusal motion has been referred and resolved in accordance with that rule. Well, we know because we was being nosy on Collin County Court page that all the county judges just adopted a rule saying you can't. It got to stay in the same court. Right? We just seen that they just did that. Did they do that of no specific and with no specific intent, or did they do that because they knew that this is what was going to go happen? You know what I'm saying? This motion is supported by affidavit because it raises matters outside the trial record established by the attached affidavits and authenticating declarations, and is timely filed and presented. Karmelo is entitled to an evidentiary hearing, and the court would abuse its motherfucking weak ass power. Oh, my bad. Would abuse its discretion in denying one. They gave a bunch of shit to see. Under these circumstances, refusal to hold a hearing would be an abuse of discretion because the motion and its supporting affidavits raise matters not determinable from the existing record that, if true, could entitle defendant to relief. State v. Pilkington. That is especially so here, where the reporter's record has not been prepared. The official court reporter has advised counsel that no portion of the trial has yet been transcribed as of July 7th. So the relevant proceedings cannot presently be reconstructed from any existing record. Come on, man. The first ground for a new trial, the trial court violated defendant's Sixth Amendment right to a public trial by materially restricting public access to trial proceedings without the findings and alternatives required by Waller, Presley, and Stricker. Let me ask y'all this. Okay, let me see. We got that. We got the four reasons for appeal. Y'all want to go page for page? Are we going page for page? Because I think now we kind of get into the thick of it. Because we done went through all that, and we are just now at the first ground for a new trial. And it's four of them. Okay, we are now on page 13 of 193. Where's this poll? Let's end this poll. Thank you to the 38 people who voted. 68% of y'all don't think that there was anything Anthony's parents could have done to stop them from railroading Karmelo. Y'all, that's not true. And I pray that y'all children, since y'all don't think that that's possible, never end up in this situation because that's simply not true. Fight for your children, okay? Fight for your children. Page for page of this entire document. Yes, God. Now, just certain key points. All right, there we go. All right. The issue is not whether the court had authority to manage courtroom security and capacity. It did. The issue is whether, after adopting an access order that foreseeably excluded members of the public from a high profile criminal trial, the court made the findings Waller v. Georgia requires and considered the reasonable alternatives Presley v. Georgia demands for contemporaneous public access. It did not. The court's order gave the general public only a 10-minute daily initial admission window, left roughly 24 seats for public observers, and a nationally watched murder trial, barred meaningful reentry during proceedings, and provided no overflow room, no audio feed, and no video feed for those foreseeably turned away. They wanted to fuck him in private. Once closure is shown, it cannot stand unless the record contains a Waller complaint justification for those restrictions. The existing record contains none. Nathaniel, not a one, Roach. Nor does the danger end with this case. In a televised interview about a case that has drawn national attention, the court publicly defended these restrictions as the right way to conduct a high profile trial, describing the decision to bar cameras and streaming as an easy decision, and stating that it had struck that balance pretty well. Should a trial be held? Should a trial held behind a 10-minute entry window with no overflow room, no audio feed, and no live stream be treated as an adequate substitute for an open courtroom? The public trial guarantee of the First and Sixth Amendments would be hollowed out in practice. The restrictions here amounted to a closure of the courtroom imposed without the findings the law requires. They don't give a fuck about the law. They don't give a fuck about the law. Karmelo does not contend that live streaming is constitutionally required in every case. The issue is that once physical seating was foreseeably inadequate, the court was required to consider reasonable alternatives and make Waller findings before excluding the public. If anybody know Carmelo mama and daddy, tell them every high profile case has some kind of legislation that comes from it. What they should do is lobby and campaign for that to be and amended and enacted into Texas state constitution. If this is a state of Texas issue, because I'm definitely advocating for cameras in the courtrooms here, they need to advocate and be at the Capitol fighting for complete transparency in criminal trials. Somebody need to tell the Anthony's there is something you can do. Fuck. An open courtroom belongs to the people of Texas who fund and sustain it. All right. Let me see. Look like I see y'all saying, hell no, don't read all this bullshit. Just get to the key points. Oh, there wasn't but one person that said that. It got four people in here. I need all four of y'all to just go on and vote. Let me know what I feel when I feel. Can y'all go ahead and vote so I know what we're doing? The openness of criminal trials is amongst the oldest and most settled features of Anglo American justice. What the fuck is. When I heard that, I think Neek was reading it. I said, what? I want to know what that means. What is Anglo American? Excuse me for my ignorance, y'all. I really don't know what it means, and I would really like to know. Damn, come on, Google. Baby, Google don't want me to know. Okay, Google, I exit over here. Ain't nobody in the chat told me either, so I don't know if y'all know or not, but I'm a hood nerd. So and I like to read and research. A demographic group in Anglo America refers to predominantly European descendant nations and ethnic groups in the Americas that speak English as a native language, making up the majority of people in the world. What the fuck? Typically refers to predominantly European descent nations. Well, I've just never heard them confirm it. I mean, I think that's something we all already knew, right? Anglo American justice, European American justice. The last 2 days of documents, they've been funny to me. They've been funny to me because it ain't like it wasn't shit we ain't already know, right? It's the fact that it's shit that we already knew, but it was never really publicly expressed. They saying it. They're saying all of the things now. The United States Supreme Court has held that public and the press possesses a right secured by the First and 14th Amendments to attend criminal trials, and that absent an overriding interest articulated in findings, a criminal trial must be open to the public. A presumption of openness inheres in the very nature of a criminal trial under our system of justice, of Anglo American justice. For a public trial gives assurance that proceedings are conducted fairly, discourages perjury and misconduct, and guards against the decisions based on secret, bias, and partiality. As the court observed, it would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. Texas has long spoken to the same effect in its own voice. The Code of Criminal Procedure commands that the proceedings and trials in all courts shall be public. How the fuck is that in y'all criminal code of procedures and then this happened? The Court of Criminal Appeals has embraced the presumption of openness recognized in Richmond newspapers, explaining more than a century ago that the Texas Constitution is but in accord with the genuine and spirit of our free institutions, which is intended to guarantee publicity to the proceedings of our court. Okay. All right, so we know how they fucked up there. Let's see what else we got. A courtroom may be closed only rarely and only in showing Waller requires. Only on the showing Waller requires. The most directly applicable appellate authority on this precise question is a published decision of this Court of Appeals handed down months before this trial began. Hey, y'all, that could be a good thing, right? So, the exact appellate court that Karmelo is facing, right? Months before Karmelo's trial, had just ruled on a trial like this. So we're going to read it and then we're going to keep going. The Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial, where the court, citing courtroom space and a generalized security concern, refused to seat one single member of the public during jury selection without first considering the reasonable alternatives the law requires. Okay, so check this out. Now we know, right? Now that we know that the Fifth Court of Appeals, the same court Karmelo has appealed to, we know that it is their own interpretation of the law that closing the court off to the public, even if it's just one member, without just cause, documented just cause, is a reason for a new trial. So if they don't see a reason for Karmelo's conviction to be overturned and him to receive a new trial, then we know that it's not because of their interpretation of the law, but something other than. That's what we know. That's what this is telling us. Somebody got a membership. Who got a membership? Although that was you getting a membership, thank you to whoever it was, baby. We appreciate you. That's what this is telling us. So because Stricker was designated for publication under Texas Rule of Appellate Procedure 47.2 subsection B, it is a published memorandum opinion of this Court of Appeals and thus the most directly applicable appellate authority on the public trial question. And having been issued months before this trial, it was available for the trial court's review when the court entered the amended order and closed these proceedings. So Roach said he didn't give a fuck about what they said. In fact, according to this document, days before they even knew this child was legally found guilty, he had already signed his right to the appeal to this court. I don't know if y'all hear what Roach and them telling y'all out there, but they just grabbed their dick and told y'all to suck it. They basically said, and what? The motherfuckers say if y'all don't give a damn, they don't give a fuck. Them motherfuckers say They gonna start this shit and it ain't gonna be no shit. That's what they said to y'all out there in Texas. I ain't gonna fuck stun on y'all because they say it to us all the time here in Louisiana. Okay? But I'd be a lying monkey's ass if I didn't say that they didn't know that I'm swell in hell when I'm well. Yeah. I'm swell in hell when I'm well. I wouldn't give a fuck if it was the governor, the mayor, the district attorney. I wouldn't give a fuck who it was, baby. You a person just like me. The difference is you was elected by the people. You're employed by the people. You are paid by the people. You in your job are your role is to serve the people. So I'm real big on accountability, self accountability, and to others. I'm swelling hell when I'm well. Anywho, the closure here was therefore not the resolution of an unsettled question. It ran headlong into a recent published decision of the very court that reviews this one. How long Roach say he been up there? Nika, we just talked about that. He been at this for decades. So how he don't know? How you ignorant? You not ignorant. You didn't give a fuck. Every justification the Fifth Court rejected in Stricker is a justification the court invoked here. They say every justification the Fifth Court rejected in the Stricker trial is a justification Roach invoked during this trial. And that rejection was on far more extreme facts, Roach's was. There, the court refused to seat one observer because the veneer, the veneer filled the gallery. The veneer filled the gallery. What the fuck is a veneer? What is this? I think that's the potential jury pool. Yeah, it is. Let me stop. I know that one. The potential jury filled the gallery. Here, the court rationed the general public to roughly 27 rotating seats across every stage of a nationally watched murder trial. There, the trial court declined to split voir dire to make room, explaining, I am not going to spend 2 days picking a jury. Fuck what the Constitution says. The Fifth Court held that space and overcrowding, though legitimate concerns, must not outweigh a defendant's Sixth Amendment right, Roach, because there are readily available alternatives and that neither convenience nor judicial economy can constitute an overriding interest. Here, the record and the court's own public statements at least raise a fact issue that reasonably alternatives existed, including larger or additional courtroom space, a live audio or video feed, and the overflow accommodation the court used during jury selection and then took the shit back. And where the Stricker court faulted the trial judge for failing to identify a specific concrete fact of danger, the order here rests on the same generic recital of Judge Roach with that bullshit. Unrestricted access may compromise security. Entered without a hearing. If excluding a single member of the public from jury selection required a new trial in Stricker, then the recurring exclusion of numerous members of the public from testimony and punishment after the court withdrew an available overflow alternative and made no wilder findings cannot be dismissed as trivial. Y'all, so I mean, I'm just saying That's it right there, huh? That should be it right there, huh? A second court of appeals reached the exact same motherfucking results just weeks later on facts materially indistinguishable from the space rationale invoked in Roach's court. In Hernandez v. State, the 14th Court of Appeals reversed a capital murder conviction and ordered a new trial because the trial court closed voir dire to the defendant's family and the public, citing an 80-person veneer and a lack of physical space without conducting a Waller analysis, making findings, or considering reasonable alternatives. The court held that I'm trying to get it up here for y'all. That the court held that concerns about space must not outweigh the defendant's Sixth Amendment rights. So that is two Texas courts of appeals. One, the one that Karmelo is appealing to, and another. And they both came to the same conclusion and admonished that the trial courts are expected to know and apply this basic rules. Hello, they said Roach was expected to know this shit and apply this shit. Touch that jar. Is the jar still hot? If that jar is still warm, they not ready. God, let the churn pickle some cucumbers, okay? The churn pickle cucumbers this morning, baby. They don't want to let the damn pickles pickle. Shit. But yeah, they say Roach is expected to know this shit and apply it. Stricker and Hernandez are thus recently published Texas decisions holding that a space based closure of jury selection entered without Waller findings or the consideration of reasonable alternatives is structural error requiring a new trial. And both were available for this court's review before this trial. Stricker and Hernandez addressed the merits of a space based closure. Dixon and the preservation authorities address when the complaint must be raised. Defendant satisfies both rules here because the closure was administered off the record and the as applied exclusion became apparent only after trial. The Court of Criminal Appeals has likewise reversed on a narrower version of this problem. In Stedman v. State, the court reversed the conviction and ordered a new trial because the trial judge excluded the defendant's family from voir dire out of a generalized concern about space without articulating a specific threat and without considering reasonable alternatives. This case is Stedman magnified at every fucking dimension. The court, Judge Roach, excluded not one family member, but the general public, not from voir dire alone, but from every stage of the trial, on findings no less generic. That unrestricted access may compromise security, juror privacy, and a fair trial without a hearing. And after using, then abandoning the very kind of overflow alternative Stedman faults courts for failing to consider, if barring family from jury selection was structural error demanding a new trial, excluding members of the public from substantial portions of jury selections, testimony, and punishment is so a 40 okay, 40. I guess that's what they say. Okay. And then in this document earlier, it said that they only got 8 seats and that his what was it, his grandparents and aunts or something was kept out of court. The Sixth Amendment to the United States Constitution guarantees the accused in a criminal prosecution the right to a public trial, a guarantee applicable to the states through the 14th Amendment. The Texas Constitution itself independently secures the same right, providing that the accused shall have a speedy public trial. The Code of Criminal Procedure reinforces it, saying that the proceedings and trials in all courts shall be public. The right to a public trial is not confined to the presentation of evidence, it extends to jury selection. Okay, so I think we got that part right. I think we're at an understanding um on the reason one. For my members, of course, I will put this document in a members only post for y'all to have all on y'all own. Okay. So yeah, all the rest of that is just speaking to the fact that they closed the goddamn court off and how they wrong for it. Jesus. They got a lot of hey. I like this new defense team. I ain't gonna lie. I like this new team. They not bullshitting. At the fuck off. Trying to get to the second one, y'all. I'm trying to get to the second one. Okay. They say finally. Baby, they not bullshitting with them. They not playing with Roach now. They say finally again. Do that mean that this the final one? I'm trying to see because I read the final one. No. Oh yeah, they not bullshitting. And when they come with their fucking case law too, Jesus. Oh, they got down into the gag order and everything. What is this? I seen the pussy name. Wait a minute, what? The point is underscored by a proceeding that unfolded outside the defense's knowledge. Before trial, a member of the public filed an emergency petition for writ of mandamus in the Fifth Court of Appeals seeking relief from the same access order as an unconstitutional partial closure. The Court of Appeals denied that petition on procedural grounds on June 4th, 2026, the first day of testimony, and the very day the overflow accommodation was withdrawn. On his motion for reconsideration, the realtor served the district attorney in the trial court, but by his own account, could not serve the defense because he lacked counsel's email address. And the appellate court's own notices of the proceedings were directed to the district attorney, not to Mr. Howard, the defendant's attorney of record, who received no notice of it. Notice facts that appear from the Court of Appeals docket and that the hearing will establish. The public access challenge was thus pending and litigated as the trial approached and proceeded. Okay, so somebody was already on it, and the state was on notice of it while the defense was left unaware. So why wouldn't they tell them? Why wouldn't they tell them that somebody was dealing with the courts trying to make sure that the public was able to see this? We already know why. That's rhetorical. That a member of the public was contesting the very closure at issue, and that the state knew of it while the defense did not. Both corroborates that the closure was real and confirms that the defendant had no opportunity to litigate or object to it as it unfolded. The record of that proceeding is, moreover, among the materials in the court's file that the court has placed under an oral protective order, so that the proof of who was and was not notified is itself withheld from inspection. A further reason these facts must be developed at a hearing. What the fuck is all them people? Where they at? Where they at? Where they at who was saying they ain't went to court, he did this, he guilty, he guilty, he guilty. He guilty, he guilty, he guilty. Where the fuck y'all at now? That is precisely this case. The court restricted public access on its own motion and administered the resulting restrictions off the record and outside the courtroom, so that the defendant had no contemporaneous opportunity to object to the closure as it actually operated. The motion is therefore the first available vehicle through which defendant could present the complaint, and it does so specifically and with particularity. The structural error is thus preserved and timely raised, and defendant is entitled to a new trial without a showing of prejudice. To the extent the court concludes that a contemporaneous objection was nonetheless required and not excused by the manner in which the order was imposed, the alternative grounds set out below independently preserve and establish the claim. Dirty dogs. In summary, okay, there we go. We're at the end of this one. In summary, the grounds and facts supporting a new trial on the first ground are these. The trial court materially restricted public access during the testimonial phase and punishment proceedings, repeatedly excluding members of the public without the findings or consideration of alternatives YALL requires. The same access regime applied across jury selection, guilt, innocence, and punishment, and it repeatedly excluded members of the public from substantial portions of those proceedings. The resulting violation is structural. The defendant had no earlier opportunity to object, and a new trial is the only adequate remedy. Should the court not find the first ground persuasive, it should next consider the second ground for a new trial. Well, what's that? The state's repudiation of the parties' unrecorded agreement limiting character evidence after the defense relied on it, they coerced the waiver of Karmelo Anthony's right to testify, denied him a complete defense, and warrants an evidentiary hearing. Toby, Shook, and Mike Howard, come on up to the front of the class. Okay? Come on up to the front of the class. Come on up to the front of the class. Throw this whole case away. The whole fucking case, Alicia. Throw the whole shit away. Throw the whole shit away. God, I done smoked so many cigarettes reading this shit. I'm rocking like a motherfucker reading this shit. I don't understand how so many people could sit back and be okay with this. The agreement, the defense, the degree, shit. The agreement and the defense's reliance. Sanabello does not involve an identical procedural setting, but it supplies the governing due process principle. That is, when the state induces detrimental reliance on a definite promise and then repudiates it after the reliance can no longer be undone, fundamental fairness is implicated. In Santabello versus New York, the state made a promise the defendant relied upon and then broke it. Through a change of prosecutors and perhaps inadvertently, the court held that the breach could not stand and vacated the judgment, even though the breach may have been unintentional And even though the sentencing judge said the broken promise had not influenced him. This is unacceptable on so many levels. Absolutely, Lee. The defense here relied on the parties' understanding through 3 successive phases of trial: voir dire, the opening statement, and the cross examination of the state's witness. And the state repudiated it only when the defense reached its own case, at the point when that reliance could no longer be undone. If the inadvertent breach in Santabello required relief, the deliberate mid trial repudiation here warrants at least the hearing this ground request. Y'all think Roach gonna give him a hearing? And then the fact that even if Roach is recused, they would have to get a change of venue completely. Let's not forget that amongst the Collin County District Judicial Court judges is Judge Willis. Prosecutor Willis's wife. The one that presided over Megan and Jeff's divorce. Why would any of these people go against Roach? This child should never have to go to court again in Collin County. If Collin County has done nothing else, they've proven themselves to be a gang. A gang that is going to stick together no matter what Texas Constitution, the United States Constitution, the Code of Ethics, none of that. They don't give a fuck. And Judge Roach said so in his fucking televised commercial. Okay. Before and during trial, the state and the defense operated under an unwritten understanding that certain character and extraneous offense evidence would be excluded and would not be offered at trial. In reliance on that understanding, the defense made strategic commitments it could not later retract. It conducted voir dire and the selection of the jury, delivered its opening statement, and cross-examined the state's witnesses, including foregoing questioning it would otherwise have pursued concerning the knife. Now, I ain't hear this nowhere else, y'all. It's new to me. Concerning the knife, what other questions would they have pursued concerning the knife? You talking about the knife that changed colors 3 times in the exhibits? You talking about that same knife that got blood in some of the photos and none in the other photos? You talking about the knife that they didn't see at first, and then a student came and told them, here you go. On the assumption that the agreed upon evidence would not be introduced. Why the understanding was never reduced to writing or placed on the record. Do y'all think that Shook, Worski, Willis, or Roach is going to agree with Mike Howard that all of this was in that agreement? Y'all think they going to... Mike, they in a club that they don't welcome you in, my boy. The agreement, by its terms, covered the defendant's own testimony. Every description the lead prosecutor gave defined the understanding by reference to what happened under the tent, and the defendant was himself an eyewitness to those events. The defense therefore understood by the plain meaning of the prosecutor's words that the defendant could testify to the incident just as any other eyewitness without opening the door to character, reputation, or extraneous offense evidence. In reliance on that agreement, the defense forbore throughout the state's case from the cross-examination it otherwise would have conducted, declining to confront the state's student witnesses with their own prior statements describing the complainant's aggression. such as that Austin Metcalf was, in quote, kind of like the aggressive guy on the team, unquote. And that came from Mason Nordyke. That he, quote, got triggered, according to Edwin Para, Eddie old bitch ass. That, quote, Austin and Hunter are not going to let you disrespect them, end quote, according to Jose Mora. That, quote, if Austin is about to get in a fight, you can tell, end quote, from Luke Stevens. I thought they wanted to protect these churn. I thought, didn't they say they ain't want nobody to know these churn names? And that Austin can be a bit aggressive at times, end quote, from Tiffany Whitaker. In the same reliance, the defense declined to designate or call its neuropsychology and forensic psychology experts, introduced none of these subjects during voir dire or opening statement, and limited its punishment presentation to three pre agreed questions of the defendant's mother. Well, now we know who them churn was. The state repudiated the understanding after inducing the defense's reliance. When the defense began to present its case in chief, the state asserted for the first time that the defense had opened the door to the previously excluded evidence through statements in its opening, and it threatened to introduce the character and extraneous offense evidence the understanding was meant to exclude. By the defense, by then, the defense had already committed to the course it charted in reliance on the understanding. Its voir dire, its opening statement, and its cross examining of state's witnesses were complete and could not be undone. A party that obtains the benefit of an opponent's reliance on a definite understanding and then repudiates that understanding once the reliance can no longer be withdrawn raises a serious question of fundamental fairness. And they quoting the Santabello versus New York again, where one party performs in reliance on the other's promise. Due process does not permit the promise simply to be disregarded. The prejudice was compounded by the court's response to assess whether the door had been opened. The court engaged in further review and previewing of the evidence. Of course, the parties' original understanding had not come to contemplate it. So Roach, of course, the court itself, let's just say himself addressed the understanding and stated that any such agreement between the parties would be unenforceable, confirming that the dispute over the alleged understanding was squarely before the court and that the defense's claimed reliance could not be vindicated through enforcement on the existing record. Let me reread it. So Roach had told them the understanding and stated that any such agreement between the parties would be unenforceable. He confirmed that the dispute over the alleged understanding was squarely before the court and that the defense's claimed reliance could not be vindicated through enforcement on the record. Roach needs to be in jail. So when Mike Howard went to him and said, "Man, look, you remember what we agreed on back there in your chambers? Man, they ain't holding up their end of the bargain. They done fucked my whole case up." Roach say, "Man, I ain't got nothing to do with that. I ain't that's on y'all." Karmelo does not, on the present record, advance a freestanding claim of prosecutorial misconduct. I do. The existence and terms of the understanding and the circumstances of its repudiation are disputed and require development at a hearing. Right. So he can't even claim prosecutorial misconduct because all they have to go on is a deposition from Mike Howard. They don't have a deposition from Toby Shook. The repudiation coerced the defendant's decision not to testify. After the state disclaimed the agreement, the court advised that it knew of no mechanism to enforce the agreement and would rule under the rules of evidence alone. And it allowed the defense only about 10 minutes after requiring counsel to preview the entire direct examination with the prosecutor to decide to decide whether Karmelo would take the stand. Forced to choose between testifying and exposing himself to the very evidence the state had agreed to withhold or preserving the forbearance the defense had already performed, the defendant elected not to testify. A 180-degree change in the defense's strategy that was the direct consequence of the breach of the agreement. What the fuck was in Carmelo's phone? What that boy had? Porn or something? Like, what the fuck? What was it? What was in his phone? A waiver of the fundamental right to testify, extracted under those conditions, is not the knowing and voluntary choice the Constitution requires. Refer to Rock v. Arkansas. A prosecutorial agreement the defense relied upon is binding and enforceable as a matter of due process. So Roach said he couldn't do shit about it. Let's see what this say about that. Agreements between the state and an accused are enforced as a matter of due process and fundamental fairness, and the court must independently assess such an agreement's effect on the constitutional rights at stake. Ricketts v. Adamson. What transforms such an undertaking from an enforceable proposal into a binding, constitutionally significant commitment is the accused detrimental reliance upon it, as in Mabry v. Johnson. A proposal on which the accused has not relied is without constitutional significance, while a promise relied upon to the defendant's detriment implicates the due process clause, as in Santabello. Here, unlike in Mabry, where relief was denied precisely because the accused had not relied on the withdrawn proposal, the defense relied on the parties' understanding continuously and irreversibly through voir dire, its opening statement, and the cross examination of their lying ass witnesses over there with the state. And finally, in the decision whether the defendant would testify. That reliance is what rendered the understanding binding and its mid trial repudiation a denial of due process. Well, first of all, Mike Howard, you need a vagina because it's much tougher and stronger than a sack of balls. Because the balls that you possess between your legs is that of someone with blue waffles. It's just worthless. It's no fucking good. What is the fucking point of those balls? Hmm? Hmm? Because this is some bald headed bullshit. This is some bald headed bullshit. Nor may the agreement be dismissed as one the state lacked power to make or the court lacked power to recognize. They call in cap on Roach. While a grant of transactional immunity requires the approval of the court, a prosecutor needs no such approval to bind the state not to use particular evidence. A prosecutor can engage in a binding agreement to refrain from using particular evidence and may bind himself to an agreement for use immunity without court approval, as seen in Graham v. State. The parties' understanding was precisely that, a mutual undertaking, not to introduce the character, reputation, and extraneous offense evidence each side had assembled against the other. It bound the state when it was made, and its enforceability did not depend on whether the trial court believed it possessed a mechanism to enforce it. These principles are not confined to the plea context. Courts enforce a prosecutor's promise and forbid the state from keeping the benefit of a defendant's reliance while repudiating the promise that induced it. As a matter of fundamental fairness, even where the breach was unintentional, and even where the promise bore on the accused's decision whether to testify, damn, where you stop it? The state here induced the defense to forego an entire category of evidence and cross examination, and then, once that reliance could not be undone, repudiated the understanding to expose the defendant to the very evidence it had agreed to withhold. The paradigm of the unfairness these decisions condemn. Where we at? We at 4 hours. I feel like being nice. Duh. I'll be nice. Fuck it. Let me end this poll too. Yeah, when I quit, I'll just quit. Fuck it. The consequence fell on the rights of constitutional dimension. The accused has a fundamental right to testify in his own defense and to present a complete defense. The mid trial collapse of the evidentiary framework on which the defense had been built and the resulting threat to expose the defendant to the extraneous offense evidence mm-mm, and the resulting threat to expose the defendant to the extraneous offense evidence the understanding had withheld forced the defendant to forego the stand and the defense to abandon a strategy to which it had already committed before the jury. Whatever the merits of the parties' dispute over the agreement scope, its effect was to deny the defendant a fair opportunity to present his defense, an injury that does not turn on which side had the better reading of the agreement. As trial counsel has sworn, the state's breach directly and significantly undermined the defense's ability to present a complete defense. Mike Howard, I'm not going to let you hide up under that. No, baby, you ain't going to cower under that. No. You see, because you had the opportunity to present a complete defense, why in the fuck would your rabbit ass even make such agreement? Whatever was in Karmelo fucking phone could not have been worse than what the fuck these churn did. You is the weakest link. You should go try to be a lawyer in another motherfucking field. Criminal law, defense attorney is just not your thing, sir. This ain't your shit. National standards confirm that such understandings belong on the record and that the state may not weaponize their absence. Professional standards reinforce the same point. An understanding affecting a client's substantial rights should be placed on the record, and a prosecutor bears both a duty of candor to the court and a duty to make a clear and complete record. Defendant's claim, however, rests on due process and detrimental reliance, not on those professional standards themselves. Okay, so they said in ABA, criminal justice standards for the defense function is what we should refer to. And ABA, criminal justice standards for the prosecution. So, according to this, Worski and Willis are actually held to the duty to have put this agreement on record, not Mike Howard. Mike Howard had a duty to his fucking client, and he should have never went into that agreement any motherfucking way. And when he seen that they didn't want to put nothing on the record, he should have made sure he found a way to put it on the record, like Ray Ray lawyer did, like the judge did in Ray Ray case. There remains a basic unfairness in who was made to bear the risk of the understanding silence. The understanding was reached amongst seasoned professionals, experienced prosecutors, and trial counsel, negotiating in the shadow of a court that itself addressed the subject. Hmm. If lawyers of that experience did not or could not reduce the understanding to a writing or a record clear enough to hold the state to it, the defendant, a young man and a recent high school graduate with no training in the law, cannot fairly be charged with having failed to secure what the seasoned professionals around him left unwritten. The defense. Oh, that was my door? Let me commercial y'all. Yeah, I just opened up the chat to everybody. Anybody can get.
Bella Muskie today. Bella Muskie today. Bella Muskie today. I don't know how to tell her. She need to get in the tub and get a groove back just like Stella. This the first time I ever smelled her. It's a little different. That cute face and nice shape, so it hit different. She reached for a hug, all I can think is distance. My baby smelling like a checker burger. Alright, y'all listen. No deodorant, no hug, that's how it goes. Speed stick, degree, hell baby, even so. Pay a little musky today. My baby, a little musky today. My baby musky today.
All right. We back. We back. We back. Mic check. 1 2 1 2. What I sound like, Lee? You can hear me? We good? We back? Yeah. A little late. So we here? Okay, yeah, we here. I see it. Hey, Kivia. Welcome over here, girl. Welcome over here. Thank you for holding it down over there in them Twitch streets. I got to reread that because that was everything. That was everything. There remains a basic unfairness in who was made to bear the risk of the understanding's silence. The understanding was reached among seasoned professionals, experienced prosecutors, and trial counsel, negotiating in the shadow, like the Ku Klux Klan, of a court that itself addressed the subject. If lawyers of that experience did not or could not reduce the understanding to a writing or a record clear enough to hold the state to it, the defendant, Carmelo Sincere Anthony, a 19-year-old young man and a recent high school graduate with no training in the law, cannot fairly be charged with having failed to secure what the seasoned professionals around him left unwritten. The defense relied on the understanding. The state accepted the benefit of their reliance and then disclaimed the understanding once its silence became useful. A process that asks the least sophisticated participant in the courtroom to absorb the consequences of the most sophisticated participant's failure to make a record is not the even handed process due process requires. At the least, the equities demand that the court resolve this dispute on a developed record rather than on the state's after the fact account. Man, mic drop. That was a motherfucking mic drop right there. The understanding, the reliance, and the repudiation can be identified with specifically with can be identified with specific specificity. That one fucked me up. And they present fact questions for the hearing. The evidence the understanding withheld was the character, reputation, and extraneous offense evidence each side had assembled against the other. As to the defendant, the acts itemized in the state's notice of intent to use extraneous offenses, and as to the complainant and his brother, that is weird as fuck. The evidence of violence, bullying, and racially motivated conduct set out in the defense's motion in Lyman. Well, I color myself wrong again, y'all, because I said that the race shit came from the politicians, the authoritarians, and the adults. I was wrong. It came from Jet Metcalf, and he gave it to his sons. And apparently, they're on record with some racially motivated conduct. And the defense was supposed to use that. Toby went and told them people what Mike Howard was intending to use. So then Toby and Worski got on the phone when they were talking about it and developed this motherfucking plan. And they knew Mike was a pussy by his own admission. And he went for it. The parties reached the understanding in a series of meetings and conversations in May 2026, culminating in a conference with the court on May 21st, 2026. And the defense memorialized it in a motion in Lyman tendered to the state and the court. That motion in Lyman is not on record. I don't see it anywhere. I don't see one single motion in Lyman. If y'all see it, please point it out to me. In reliance, the defense conducted voir dire, delivered its opening statement, and cross-examining the lying ass witnesses for the state without introducing the withheld evidence, and it shaped its case around the decision to call the defendant to testify. The defense began its case on June 6, 2026, and continued it on Monday, June 8. On that final day of evidence, the state came in and told them for the first motherfucking time that they had already opened the door in their opening statement and that the understanding had never contemplated a testifying Carmelo. And the court advised the parties that it had no mechanism to enforce the agreement. So, yeah, at the bottom it says that they had a heightened duty of candor to the courts, duty to make clear and complete record, including by placing explanations on the record, and would rule under the rules of evidence alone. Faced with that repudiation, the defense abandoned its plan to call the defendant and to present certain expert testimony. The state's own conduct then corroborated the understanding it had just denied. At punishment, it called no witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice. Resting its punishment case immediately, precisely as Mr. Worski had described on May 11th, the agreement would operate a matter the reporter's record will confirm. The state's punishment presentation is circumstantial evidence from which the court may infer the parties' shared understanding. At minimum, it is a fact that should be explored at the evidentiary hearing, and the final ledger confirms the asymmetry of the breach. Neither side ever introduced the character evidence the understanding covered. That's a lie. They told Carmelo character up the whole time. The state's forbearance cost it nothing because the defendant, silenced, never opened any door. While the defense lost the one witness who was necessarily present under the tent in a self defense case that required his testimony, these facts are disputed and can be resolved only through testimony. Oh, okay. So they say them facts being disputed. So I guess that answers my question on whether Worski, Willis, Roach, and Shook will agree that these things happen the way Mike Howard puts ads say they happen. The agreement was never reduced to writing, embodied in an order, or recited on the record when it was made. To complete the record, the defense both furnished its own recitation of the agreement in trial counsel's affidavit and requested the state's by email date June 25th, 2026, to counsel for the state. Undersigned counsel asked whether there was some type of agreement between the state and defense regarding extraneous offenses, whether it was not reduced to writing, and if so, for the state to state what you believe the agreement was from the state's perspective, and further inquired about the procedure by which pleadings were delivered to the court but received and not filed, and about any written waivers signed by the defendant or his counsel. June 2020, June 25th, 2026, email from undersigned counsel to counsel for the state. As of the date of this motion, the state has not provided a responsive factual recitation of the agreement. Of course not. Of course not. Why would they? An evidentiary hearing is required. The existence, terms, and repudiation of the understanding and the strategic decisions the defense made in reliance on it are disputed and cannot be determined from any available record, particularly because no reporter's record of the relevant proceedings is available. These matters can be established only at an evidentiary hearing at which trial counsel and, if necessary, the prosecutor may testify. Trial counsel's account is set out in the accompanying affidavit and will be presented at the hearing. Defendant accordingly requests an evidentiary hearing to determine the existence and terms of the understanding. The defense reliance on it and the circumstances of its repudiation. In summary, the grounds and facts supporting a new trial on the second ground are these. The state induced the defense to try its case under an unwritten agreement limiting character and extraneous offense evidence, foregoing cross examination, witnesses, and its own client's testimony in reliance of that agreement, and then repudiated the agreement after the defense had performed, coercing the involuntary waiver of the defendant's right to testify and denying him the right to present a complete defense. Because the agreement and its repudiation were placed off the record, an evidentiary hearing is required to resolve them. Should the court not find the second ground persuasive, it should next consider the third ground. Child, thanks so far. Do y'all think that the court reporter is going to transcribe in truth and in facts? Something in me is telling me that Roach, won't release those records to be transcribed because he may be getting a little pushback on how he wants them transcribed. And the only thing came to my mind was the Diddy trial, right? If famous people can be criminally charged because a hoe that go says that if they didn't go, their whole career would be taken, right? Like it ain't like they can go work somewhere else. Then what happens to a judge or a prosecutor when they are demanding that their staff must assist them in this bullshit or get fired and never work in Collin County again? If you have bore witness to the bullshit these people have done unanswered, but you ain't never had to participate in it, right? And now they say, I'm finna give you what you are going to type as a transcription. What you gonna do? See me? I'ma record the bitch. I'ma act like I'ma do it. I'ma record them. It's about integrity at the end of the day, right? I'ma record them. I'ma act like I'ma do it just so I can get proof. Cause bitch, don't play with me. Play with your bitch. The third ground for a new trial. The court's unsupported provocation instruction improperly limited the defendant's right to self defense. Okay, I think we get into the jury instruction now. This is what I wanted to read. This is what I hadn't heard yet. A provocation instruction limits the right of self defense and may be given only when the evidence supports all three elements. A provoking the difficulty instruction is one of the few charges that can take a defense away from the jury altogether. Properly given, it tells the jury that a defendant who provoked the encounter forfeits the right of self defense he would otherwise enjoy. For that reason, the Court of Criminal Appeals has held that the instruction may be submitted only when the evidence support each of its three elements, and that giving it without that support is in error. See Smith v. State. Here, the instruction was given without that support, and it did to the defendant's self defense case exactly what an unsupported provocation charge always does. It invited the jury to set the defense aside before even weighing it. On a record in which self defense was the heart of the case, that error was not harmless and it requires a new trial, as seen in Almanza v. State. The defendant's defense at trial was self defense, and the jury was charged on the justified use of deadly force. The court's charge, however, Roach bitch ass, however, also instructed the jury on provocation that the defendant forfeited his right of self defense if he provoked the difficulty. Yes, sir. Where you at? Man, you live an hour away. Get off my phone. If y'all leave me alone and let me finish my show, I can't even get through my shit. So, man, if you don't get the fuck off my phone with your little toy truck them people gave you, nah. Yeah, bye. Fuck. Told y'all, bro. They don't give a fuck about y'all. They don't just. I can't. Imagine me working from home. Imagine me actually having a 9 to 5 and it's working from home. Girl. Jesus. Good googly moo. At this point, I hope he leave me. I don't want to go. Who the fuck want to go stuck in the fucking car with the goddamn churn in the goddamn way? Fuck. He leave. Girl. Little girls. The defendant's defense at trial was self-defense. That's I already did that. Where I'm at? Where am I? Kinfolk want to interview. Girl, he done been on the panel and everything. That's my brother. He done been on the panel and everything. The one Trey that was up here talking about what kind of woman he want. I be glad when he get him one. Fuck, they get on my nerves. I got three brothers. The one who used to get on my nerves the most is now married. Thank God for my sister-in-law. My baby brother, he don't bother me. Anytime my baby brother coming around, he coming around like he the big brother. Okay? But this other one, oh God, he's so needy. He need a bitch. I don't even remember where I was. Roach charge, however, also instructed the jury on provocation that the defendant forfeited his right of self defense if he provoked the difficulty. A provocation or provoking the difficulty instruction is a limitation on, and in some cases, a negation of, right, the right of self defense. And for that reason, it should rarely be given. Smith v. State. It may be submitted only when the evidence supports each of three elements. One, that the defendant did some act or used some words that provoked the attack on him. So this is why I remember saying they act like the boy had Tourette's. They talking about Carmelo came under the tent and all they did was ask him to leave. And he just started howling, touch me and see what happened. Touch me and see what happened. Like, what nothing said to him before then. He just had Tourette's. I bet you won't touch me. That's that's why they did that. Two, that the act or words were reasonably calculated to provoke the attack. And three, that the act was done or the words were used for the purpose and with the intent that the defendant would have a pretext for inflicting harm upon the other. If any one of the three lacks evidentiary support, the instruction must not be given. They had to meet all three of them. If anybody think they met one of them, please tell me which one you think they met. And of course, it's just all a matter of opinion because Roach will not release the fucking files to be transcribed, right? But maybe that's why Eddie was acting like he didn't know who Carmelo was. Maybe that's why Eddie was acting like he didn't tell Carmelo, man, come get out the ring. You come sit over here. Because then it seems like Carmelo was just on a hunt for somebody to use his multi tool on. The charge here gave such an instruction. It directed the jury that if the defendant immediately before the difficulty did some act, used some language, or both with the intent to produce the occasion to bring on the difficulty and kill Austin Bully Metcalf, and that such conduct was reasonably calculated to and did not provoke a difficulty, to which the Metcalfs responded by attacking or appearing about to attack him, and that the defendant then killed Austin Metcalf in pursuance of his original design, the jury would find against the defendant's claim of self defense. The instruction thus stripped the defendant of self defense upon a finding that he provoked them bully bitches with a preformed intent and original design to kill him. I ain't gonna, yeah, fuck that. I'd rather my boy be dead and gone than for him to be a child with his whole future ahead of him, doing everything right. And then because he was defending himself, this was how he experienced for the first time the American judicial system. No street in him whatsoever. This has to be hell. This has to be hell. That child, that child has to be in fucking hell. They keep saying he good. He gonna get out. Man, imagine going from the life he had to being thrown into this shit at no fault of his own. All because something was in his phone. If whatever was in his phone was not something that he could be criminally charged and sentenced to 35 fucking years for, bring it out, bring it out. The fuck is he paying a lawyer for? Fuck you say this child good in prison. Was fucking headed to college. I'ma tell y'all, it's a lot of fucking days that I be feeling like maybe I should have raised my boy up in them quarters. Maybe I should have never changed when my kids got older. Maybe I should have just stuck to the motherfucking quarters and what's in me. Maybe I should have raised my children to be the killers. It's so fucked up that that's how watching what go on in the world make me feel. When my pride and joy as a mother was that I raised good people. Fuck. The evidence did not support submission of the instruction. Even viewing the evidence in the light most favorable to submission of the instruction, the record did not permit a rational finding on the third Smith element. The state may point to evidence that the defendant remained in the area, exchanged words with Austin Metcalf, possessed a multitude. Why the fuck are they still calling it a knife? Or took part in a confrontation. Even credited such evidence does not show that the defendant acted or spoke with the purpose and intent to provoke them bully bitches attack as a pretext to killing. Provocation requires more than words, presence, poor judgment, or participation in a confrontation. It requires evidence of a preformed design to create occasion for deadly force. The evidence did not support submission of that instruction. The third Smith element, intent to provoke as a pretext to inflict harm, was absent, and the charge demanded even more, requiring a finding that the defendant acted with the intent to produce the occasion to bring on the difficulty and kill the bully, and that he killed the bully in pursuance of his original design. There was no evidence that Karmelo approached or spoke to the bully with a preformed design to kill him under the pretext of self defense. The evidence raised, at most, a sudden confrontation in which defendant used force he believed immediately necessary to protect himself. Submitting a provocation instruction on this record was error because it authorized the jury to deny the defendant his right of self defense, even if he otherwise acted in lawful self defense. This same unsupported provocation theory also tainted the charge's no retreat instruction, which withheld the defendant's stand his ground protection unless the jury found he did not provoke the bully. The error was harmful and requires a new trial, and it was preserved. The defendant objected to the submission of the provocation instruction. Thank God, because the error was preserved. Reversal is required upon a showing of some harm. In Almanza v. State, preserved charge error is assessed in light of the entire charge, the state of evidence, the arguments of counsel, and any other relevant information. The harm here is plain. Self defense was the central contested issue at trial, and the state did not let the erroneous instruction lie. In closing argument, the prosecution firmly relied on the provocation instruction, urging the jury to invoke it to deny the defendant his right to self defense. An instruction that wrongly authorized the jury to set aside the defendant's only defense, and that the state pressed in summation caused harm well beyond the some harm threshold and requires a new trial. Trial counsel's affidavit establishes that the defense objected to the provocation instruction and that the state relied on the instruction in closing. The defendant will supplement with the reporter's record when it is available, if it is factual. In summary, the grounds and facts supporting a new trial on the third ground are these: the trial court submitted a provocation instruction unsupported by the evidence, which improperly withdrew the law of self defense, the defendant's sole contested defense, from the jury's full consideration, and the error was both preserved and harmful. Should the court not find the third ground independently persuasive, it should grant a new trial in the interest of justice for the reasons stated in the fourth and final ground. A new trial should be granted in the interest of justice. Finally, and in the alternative, the court should grant a new trial in the interest of justice, even where no single ground independently sufficient, their cumulative effect, a trial in which public access was materially restricted during the testimonial phase amid trial repudiation of the parties' agreement that coerced the defendant's silence and gutted his self-defense presentation, an unimposed, I'm sorry, an unsupported instruction that narrowed that same defense, deprived the defendant of the fair, open, and adversarial trial the Constitution's guarantee. The court retains discretion to grant a new trial in the interest of justice where a valid legal basis supports it, State v. Herndon, and the grounds above supply that base. Hey, come here! Excuse me. Come here. Y'all see what it looked like out there? Y'all had fun. I came and looked at y'all. I saw y'all. Y'all was snapping it up on the back of the truck and everything. Stop. Look, what it looked like outside. It looked like nighttime to y'all. What that mean? Absolutely.
But Blue is trying to chase us, and he's trying to bite
He
us.
not in the house, is he?
No, no.
Are you bitten?
I got bit.
Did Blue bite you?
I got bit.
Where?
Me too. On my leg.
Let me see. Did
And
it
I
break the
got
skin?
scratched. See?
Are you bleeding? Did it break the skin?
No, but it was bleeding. It was
Okay.
bleeding.
Ooh, y'all stink like outside. Listen, y'all don't smell like pretty little girls. Come on, move back. Get out of my way. Go find y'all some pajamas so I can draw y'all some bath water.
I don't have no more. I used my shoes.
No, you don't, because I washed everything. Yeah, baby. And before y'all touch them clean clothes,
Go wash my hands.
I came and I saw y'all outside playing, which means I saw my living room. What do y'all think I want y'all to do? Oh, yeah, baby. See, y'all so smart, baby. Ain't the, y'all smarter than the judge. Prayer. Wherefore, premises considered, the court restricted the general public to a 10-minute delay admission window and provided no contemporaneous alternative for those foreseeable turned away, without the findings Waller requires. The resultant closure is structural error that a new trial is required to cure. Defendant Carmelo Sincere Anthony therefore respectfully prays that the court set this motion for an evidentiary hearing at which the facts concerning the closure of the courtroom, the delegation of the courtroom access determination to a non-judicial officer, hmm, the parties' unrecorded agreement limiting character evidence and its repudiation, and the preservation and harm facts concerning the unsupported provocation instruction may be developed. Grant the motion, set aside the judgment of the conviction and sentence, and order a new trial conducted in a courtroom open to the public. Enter written findings of fact and conclusions of law in support of its ruling. Grant the relief requested in the interest of justice, and grant such other and further relief to the defendant may be justly entitled. Okay, so we got through that. I wonder how long do they have to answer that? They presented it to Roach. Oh, July 6th.
Brooklyn had said that you told her she could have my box.
I told her break your box.
She ain't.
Okay, well, what I'm gonna break it. I'm throwing all this shit in the trash. I love y'all. Please go clean my living room. Matter of fact, since your box isn't broken, take all that trash that y'all got, including your broken box.
But she took it.
Okay, what am I saying? Tell Brooklyn come in so I can tell both of y'all then.
Brooklyn, come here. No, nobody had a box.
Okay, so that we already seen. Okay, so check this out. The box that's not broken, bless you, baby. The box that's not broken, take all y'all trash, including the broken box, and put it in there. Thank you. Baby, they done broke my mouse. Fuck. Exhibit 2. Okay, this is the register of actions. Again, I don't see a motion in lineman. Let me make this bigger for my own fucking good. Let me know if y'all see a motion in lineman. How? Where? In the house? Did you bring it in? Okay, well that means it's in the house. Probably if y'all. Oh my god. Hey, it's okay. If it's in the house, it's somewhere under the junk y'all made. Go clean up. Go clean up. It doesn't matter. You're not. Listen. You apologizing is for you. They don't have to accept your apology. Going to pick up my son. I'm probably gonna be gone, Lee. The girls back in. Yeah, we probably gonna have to part two this with all the evidence and so forth. Yeah, yeah. Cause I need to bathe them and get them together. They let me come on here for 4.5 hours. Okay. It was not 4.5 dedicated hours, but hey, they breaking shit. Yeah. No, I don't see that. Mm-mm. Nope, I don't see that. And all this is post trial shit.
I'm gonna go home today.
Are you finished cleaning?
We can't see in there.
Turn the light on.
We don't know how.
So you don't know how to get the remote and turn the light on?
We don't know where the remote is.
All right, here I come. All right, y'all. Cool. So look, now it's time to say goodbye to all my internet friends. I hope y'all enjoyed. We'll go over the bottom button. We will go over um the rest of this when I ain't got nobody in my house. Probably tomorrow night. And these are just all of their exhibits. I think we've seen most of these. Yep, we went there. I showed y'all that. The only one that I would like to just cover in its entirety here in the quarters is the puss ass nigga. His deposition. Okay, that's Thelma. Yeah, so we'll get to that in part two. Okay. Yeah. So thank y'all for hitting the like 24 times. Okay. Thank y'all for hitting the like 24 times to the 200 and some odd of you. Shout out to my mods that were in attendance and helped me. Okay. Thank you to those over there in the Sonya quarters of Twitch streets that held it the fuck down. The new subscribers over there. Thank you for taking your hard earned money and investing into the platform. Please believe me, it is much appreciated. Nurse P with the bits. Okay, okay, okay.
She said she want to go look outside to see if it's out there. I said
Have y'all
can
cleaned?
we go look outside?
Yep. Yep. Let me get off of here. Yep. Thank y'all. Thank you, Kivia. Thank you. Thank you. Thank you. I appreciate all y'all support. Let me find this and get to this. All right, y'all. Let me go.